All rise. You may be seated.
Good morning, ladies and gentlemen.
Good morning, ladies and gentlemen. I'm Justice Sanju, and today we are gathered here to hear upon the validity of the Anti-Terrorism Act. The justices will be hearing arguments from the representatives of the Crown, the representatives of the defense, and interviewers present in the courtroom today. A question period will follow, during which the justices will voice any concerns which they have with the arguments presented today. I'd like to take the time now to remind all present in the courtroom that anyone and everyone disrupting the court while in session will be held in contempt of court and will be removed from the vicinity. The justices will now like to hear the Crown's opening statements.
Good morning, Your Honors. My name is Terrorism, and these are my fellow teammates. Dr. John, Malik Sands, Sabrina Mangu, and Nishan Singh. And today we will be representing the Crown. Now, to begin, can I proceed? Public safety is a growing concern because of the dangers that currently pose to individuals as well as society. At every area of public life, it is important to implement measures to ensure public security so that health and normal life is always maintained. Some threats within society are severe, and after the September 11 attacks, the concern of public safety is now more than ever. The Anti-Terrorism Act, Part 2.1 of the Criminal Code, was passed in 2001 in the aftermath of the Al-Qaeda attacks in the United States to take steps to prevent and suppress terrorist activity. The purpose of this legislation is to provide a means by which terrorism may be prosecuted and prevented. Terrorist activity has the potential to destabilize and destroy the very institutions and values that define our democracy. Recognizing the rule of law as an overarching principle, the Charter rights and freedoms of particular importance to this review are freedom of thought, belief, opinion, expression, conscience, religion, peaceful assembly, and association. Section 2. Security of the person, including privacy. Section 7. Equal protection and benefit of the law without discrimination. Section 15. And security against unreasonable search or seizure and arbitrary detention. Section 8. And the right to a fair trial and the presumption of innocence until proven guilty. Section 11. Now, in the case of R versus Donovan, the issue that is brought to the courts again is the disclosure of evidence for proposed sides. Section 30 and 39 of Canada's Evidence Act is present to protect society by preventing the disclosure of information that can pose a threat to international relations, national defense, or national security. And second, to prosecute individuals accused of offenses against our laws. The Anti-Terrorism Act speaks for these laws as they are enforced for the safety and security of our society. Now, since 9/11, the uncertainty of liberty versus security is also being discussed in Canada like never before. The thought of emergency and that an emergency situation can take place at any time is having made a huge impact in our political world. Formal jurisprudence, instrumental jurisprudence, and jurisprudence of values are behind how we live in emergency situations. Each is a type of basic constitutional reasoning. They can be seen in cases that involve deportation, while in those cases the court's decisions are taken into consideration through one of these jurisprudences. The question then remains, when dealing with emergency situations and terrorism, which jurisprudence is best suited? Also, after the events of September 11th, preventative measures were taken worldwide to ensure such events did not occur again at the hands of extremist groups, and North Americans realized that they are no longer geographically isolated from such terrorist activity. An article by David Jenkins compares British, American, and Canadian legislation and explains how Canada's Anti-Terrorism Act is a well-drafted and effective contribution to the prevention of terrorism.
1 minute warning.
Adele Chinguacousy, a permanent resident of Canada, was named a security certificate jointly issued on May 9, 2003 by the Minister of Citizenship and Immigration and what was then the Solicitor General. Now, as a member of the public, it is necessary to ensure that all precautions are in place in the event of a warning about an environmental disaster or attack from an external agency. It is further enhanced when professionals and members of the general public cooperate to ensure all systems for public security are placed and conditions laid down to maintain safety are followed in the right manner. Again, the Anti-Terrorism Act is in place to protect society from harm and threats that may be posed by terrorist activities, as terrorists are criminals and public needs to be protected from them. The Crown solely believes that the Anti-Terrorism Act should stay in place. Thank you.
Does the Crown have any further arguments?
Yes, Your Honor.
My name is Terrence Hoda, and I'm here to represent the Crown. Your Honors, may I proceed?
You may proceed.
Now, this article by David Jenkins is titled, "In Support of Canada's Anti-Terrorism Act, a comparison of Canadian, British, and American anti-terrorism law." We compare British, American, and Canadian legislation and explain how Canada's Anti-Terrorism Act is a well-drafted and effective contribution to the prevention of terrorism. Now, the events of September 11th had a huge effect on the world's perception of terrorism. They displayed how extremist groups are able to operate in North America. And now, despite the United States being the most likely target, Canada is also at risk. Now, 3 reasons for terrorism in Canada. First, the Millennium Bombing plot and the 2 World Trade Center attacks. There are no Canadian links to all 3 of the attacks, making Canada just as vulnerable. Also, the unpredictable nature of terrorism makes attacks conceivable to occur on Canadian soil, considering Canada's role in Afghanistan and Israel and their close ties to the United States. Third, the secrecy surrounding terrorist group operations in Canada not only increases the unpredictability of the attacks, but also hinders law enforcement efforts in investigating and preventing violence. Because of these factors, Canada has taken firm, positive steps without overreacting to investigate, punish, and prevent terrorism by enacting the Anti-Terrorism Act. Now, the Anti-Terrorism Act defines terrorism, creates new terrorist offenses, and takes preventive measures against terrorist activities before they result in violence. Now, 3 things the Anti-Terrorism Act intends to do. First, it intends to identify, prosecute, convict, and punish terrorists. Second, it intends to grant more investigative powers to both law enforcement and national security agencies. And third, it intends to attack terrorism at its foundations by strengthening provisions related to hate crimes and dissemination of hate propaganda. The Anti-Terrorism Act amends the criminal code to include new offenses, defining terrorist activity as an action within or without Canada that is a violation of any one of 10 listed United Nations anti-terrorism conventions. This includes actions taken for political, religious, or ideological purpose, objective, or cause. and threatens the public or government by seriously killing, harming, or endangering a person, causing substantial property damage that is likely to seriously harm people, or by interfering with or disrupting an essential service, facility, or system. This act also makes it a crime to fundraise for or assist designated terrorist groups and launder money on their behalf. New investigative powers for law enforcement allow the preventative arrest of suspected terrorists and the compulsory testimony of individuals in an ongoing terrorism investigation. Now, safeguards include interpretive clause emphasizing that legitimate demonstrations and protests do not constitute terrorist activity, and the sunset clause allowing expiration of compulsory testimony and preventative arrest provisions. Finally, the Anti-Terrorism Act addresses root causes of terrorism by prohibiting hate-toward propaganda on internet sites and criminal mischief against places of religious worship. Now, the United Kingdom broadly defines terrorism as threatening or harmful actions having religious, ideological, or political motivations intended to intimidate the public or influence the government. The Terrorist Act of the United Kingdom prohibits participation in fundraising and money laundering on behalf of terrorist organizations. Law enforcement receives stronger investigative powers to condone areas, stop and search vehicles or individuals, and preventively arrest of suspected terrorists. After September 11, they passed the Anti-Terrorism Crime and Security Act, which strengthened immigration controls, attacked terrorist assets, and expanded hate crime laws. The United States, prior to September 11, defined terrorist activity as acts intended to intimidate the civilian population or coerce the government, forbidding fundraising for terrorist organizations. After September 11, the Patriot Act was passed, which expanded law enforcement's authority in areas of electronic intelligence gathering, foreign intelligence surveillance, detention and removal of aliens engaging in terrorist activity, substantive criminal law and criminal procedure, financial infrastructure, and general emergency authorization. Now, this act dramatically tightens immigration controls, prohibits harboring and supporting terrorists, and targets terrorist property. Now, despite these additions in the United States, their act only builds upon existing legislation and is not a comprehensive restructuring of anti-terrorism framework. Now, why is this comparison of Canada, UK, and the USA valid? Well, first, the threat of international terrorism is a concern for all three nations. The operation and financing of terrorist groups within and across borders demonstrates the need for intensive action in identifying, investigating, and preventing terrorist activities. It is a global effort and a global threat requiring international efforts at all levels. For instance, the United Nations Security Council expressed its international concern for terrorism, stating that international terrorism endangers the lives and well-being of individuals as well as the peace and security of all states. Terrorism further threatens the social and economic development of all states and undermines global stability and prosperity. Therefore, terrorism is a common threat requiring not only direct action at the level of international law, but also indirect collaboration through common security policies and domestic anti-terrorism cooperation. The law is an important means of indirect cooperation. Now, in this case, the fight against terrorism mandates state action, and terrorism pressures states to bond in a new way to fight a common threat. Now, the comparison of these three nations and these legislations promotes harmonized, cooperative, and effective responses that promote international law. Also, the legislation of these nations can be useful when drafting or considering anti-terrorism measures, ensuring these countries tailor their anti-terrorism laws to respect rights while adequately defending public safety that supports rights. Now, defining terrorism. Terrorism is an activity sometimes considered elusive to a precise definition. As brought up by American Justice Potter, which you can refer to on page 431 of David Jenkins' article, and I quote, "Terrorism is difficult to define, but one knows it when he or she sees it," end quote. Now, terrorism, however, is a highly irregular technique of armed conflict, often organized and waged within and against the civilian population at large, thus distinguishing it from regular crimes. The terrorist use of violence to threaten and intimidate the public and government is their way to impose their motivating ideology in an undemocratic and opposing way. Now, Canada, the UK, and the USA. They share three aspects that address international terrorism. Those are particular harms, motivation as an essential element, and extraterritorial jurisdiction. In terms of harms, the Anti-Terrorism Act defines terrorist activity in two ways. First, such activity includes any act or omission that is committed in or outside Canada, and that, if committed in Canada, is an offense under 10 designated international conventions for the prevention of terrorism. Second, the Anti-Terrorism Act includes acts or omissions in or outside of Canada committed in whole or in part for a political, religious, or ideological purpose, objective, or cause. Such acts must be done in whole or in part with the intention of intimidating the public or a segment of the public with regard to its security, including economic security, compelling a person, a government, or an organization to do or refrain from doing any act, whether the person or public or government or organization is inside or outside Canada. These acts must intentionally cause harm by resulting in or attempting to cause death or bodily harm, serious risk to public health and safety, property damage that might result in such harm, or disruption of essential services, facilities, or systems. Concept of harm also extends to public health and safety as well as essential services, facilities, and systems. Now, by including these types of harm, the Anti-Terrorism Act can prevent and punish those activities intended to cause mass and indiscriminate harm, or to destabilize society through attacks on its organizational, institutional, or economic well-being. Now, the British defines terrorism as a use or threat of action where the use or threat is designed to influence government or to intimidate the public or a section of the public and is made for the purpose of advancing a political, religious, or ideological cause. Now, this definition is similar to Canada, including committing violence against a person, endangering life, or posing a risk to public health and safety. It includes serious property damage, but this definition is broader than the Canadian definition, as property damage need not likely result in personal or public harm, thus arising issues with charter rights. Now, the American definition differs from both Canada and the UK, as it does not list specialized harms. Instead, it generally covers actions that involve acts or acts dangerous to human life that are a violation of the criminal laws of the United States or of any state, or that would be a violation if committed within the jurisdiction of the United States or any state.
1 minute warning.
In terms of association, Canada's Anti-Terrorism Act makes it a crime for anyone to knowingly participate in or contribute to, directly or indirectly, any activity of a terrorist group for the purpose of enhancing the ability of any terrorist group to facilitate or carry out terrorist activity. To participate in or contribute to terrorist activities includes such things as recruiting members, offering skills and services, entering or remaining in a country at the request of a terrorist group, or making oneself available for the commission of a terrorist offense within or outside Canada upon instruction from a group member. And it also includes to instruct someone to perform activities to benefit a group's ability to facilitate or carry out terrorism. Now, in terms of financing, Canada, UK, and USA have similar measures on financing. Quoting the Solicitor General of Canada on page 446 of the article, and I quote, "To defeat terrorists, we also need to choke off their money supply," end quote. One of the main purposes of recognizing a group is to target its role in fundraising and conducting transactions, sometimes under the disguise of charity work. Disruption and elimination of their money supply is a long-term strategy to eliminate and prevent terrorism.
Thank you.
Does the Crown have any further arguments?
Yes, Your Honor. May I proceed? Okay. Hello, my name is Reverend Tremont and I'm representing the Crown. In the case that
Chinguacousy versus Canada. May I proceed? Now I prefer Mr. Chinguacousy to proceed. In Canadian law, the certificate tool of the government of Canada to take of deporting foreign nations and other non-nations living in Canada. The federal government had issued a certificate if a permanent resident or a non-citizen or alleged to violate human rights of members of the organization of a crime, or alleged of threatening the nation's security. Security is determined a reasonable proof of a person's and prohibits the removal of the force which is necessary to hold and continue examination for a hearing. Mr. C was a permanent resident in Canada. He was named in this certificate issued on May 9th, 2003 by a member of the Minister of Citizenship and Immigration that had been a Solicitor General. The warrant had been issued on May 16th and effective on May 21st, at the point of which he was detained until conditional releases, which ordered in February 2005. As a person named in the security certificate, Mr. C was throughout this period detained and access of evidence disclosed, and which, in the view of judges, reviewed a reasonable certificate, support nations and safety in a person. Undefined to Mr. C, the evidence should be considered by reviewing the judges, jury, from the basis of decision of reasonableness to the certificate. According to Section 80, the Immigration and Refugee Act, the certificate found to the reasonable stance is such a proof of a person that is unrelated to Canada and the services of the effect of the order. Facing the deportation alleged terrorists unable to detain Mr. C began a series of constitutional challenges. The security certificate, Chinguacousy versus Canada, certificate in citizenship of immigration, and certificate in immigration of citizenship and immigration. He argued that the certificate was unfair and disclosed and related information named a person violated Charter 7 rights to against them and prohibiting the name of a person. Okay, none of these claims were assessed in a federal court's level. In Chinguacousy, however, the Supreme Court of Canada ruled that the levels of security were infringed, named a person's Section 7. To adhere to a fair hearing and principle which the name of a person is detention and deportation based, the risk of remarkable circumstances of torture and similar abuses. The government of immigration and special advocates, SA, to access these challenges to a reliable and evidence tendered during the senior hearings. The judgment helped the criminal law evaluate the fairness and challenges of proceeding. Mr. Chinguacousy, of the fairness and approval level disclosed challenges of interest of ministers and retained to disclose the further reviewing. Judges were forwarded to the person's accuracy of the summaries of the information that was given and information that was disclosed. of reasons and national security of any person. Without standing, the minister argued to Lamar J. was found that the citizen that the certificate and certificate was disclosed to Mr. Chinguacousy. Without the promising the national security, the safety of any person, she proceeded to the ministers and disclosed the evidence directly. The further argument is that Mr. C was submitted during the closed hearings and copied the thesis and of the evidence that J. Lamar indicated that the following summaries of the original information was included in details of the ministers safely disclosed. All the judges are not based on the decision of the information that was evidence in the ministers shall return to ministry. The judges determined that they are not relevant to the ministers and withdraw it. Thus, given the ministers in July 31st, 2009 lacked enough evidence to support the reasonable certificate. The court resolved all these questions at once. According to the following questions of the ministers. The judgment. The ministers were supporting information that referred to Mr. Chowley's certificate to the federal court, section 83. The withdrawal of the evidence of the review of the judges was basically baselining of the decisions that were in the information submitted in the formal necessary function of section 77. Non-exist support was deciding on the certificate reasonable and certificate was unjustifiable. And accordingly to directed to the terms of law. The court was not arguing that section 77 was a benefit of the fact that the evidence that the judges investigated filed on Mr. Chinguacousy's case. The judgment of allowing the disclosure obligations. Once the ministers would have revealed and withdrawn information and proceed through, none of this would happen. But for these reasons, they are clear to Mr. Lamar J. justified that the minister's questions of court of appeal in any or regard to the legal or action of under the IRPA. But in another way, the answers in the future questions were not presenting the arrival through the improper means. It's true that the court ruled that the reasonable certificate rather than declaring it annul. Lamar J. stated that on certain terms that she would have certificate of reasonable and approach, and however she was discussing the security and questions and the court of appeal.
One-minute warning.
The certificate was released on high-profile captive. The judgment was a criticism of ministers and extra power discussed upon by the parliament. This was not just the matter of the judges replacing a personal value of those government and in favor of the rights of non-citizens and public interests, safeguarding and the national security operations. This is increased a matter of her training and the judgment of her upon the parliament, giving the federal court a truck to report the area of the ministers could release and supplies and house suddenly held reviewing the judges have studied on.
Thank you.
Does the Crown have any further arguments?
May I proceed? Hello, my name is Lee Sands, and I'm representing the Crown. With my article, Aftermath of 11 September 2001, Liberty versus Security, before the Supreme Court began. Since September 11, 2001, the constant battle of terrorism and issues have been at the top of concerns that the public has. In December 2001 was when the Anti-Terrorism Act was passed and started a long, uncertain talks between Liberty and Security and Canada. We're in the beginning of the Anti-Terrorism Act. Parliament has this to say. Quote from paragraph 6 of the preamble of the Anti-Terrorism Act. Quote, whereas the Parliament of Canada recognizes that terrorism is a matter of national concern and that affects the security of the nation, is committed to taking comprehensive measures to protect Canadians against terrorist activity while continuing to respect and promote values reflected in the rights and freedoms guaranteed by the Canadian Charter of Rights. Unquote. Basically, terrorism is a great concern for the safety of our public. We will continue, it's a great concern for the safety of our public. I will continue to respect and keep in mind the Charter when dealing with issues of great concern. The Anti-Terrorism Act is a big step in dealing with terrorism and the safety of Canadians, as it is positive to keep society safe. I know my sense since September 11th regards the authority of international human rights law, especially where heavily sensitive security matters are concerned, including deportation of political refugees that are expected to be connected with terrorist organizations. To show this, a study from Michael Keogh shows the difference between different kinds of constitutional reasoning. There are three supreme types of basic constitutional reasoning he speaks of: formal jurisprudence, instrumental jurisprudence, and value-based jurisprudence of values. The three types look at how we can justify emergency situations since 9/11 and the idea of emergency, and that any possible emergency can happen at any time. Formal jurisprudence, quote, in the sphere of constitutional law, formal jurisprudence consists of any construction of constitutional norms upon purely formal criteria, such as literal interpretation, original intentions, unvocal legislative intent, etc., and in doing so, viewing itself as an objective interpretative approach. That is to say, that proponents of the formal jurisprudence see the judge task as being essential, value neutral, purely logical application of pre-existing unvocal norms. Unquote. Page 360. This jurisprudence on dealing with constitutional law is put together by fundamentals of the Constitution, depending on basic standards, examples as literal interpretation, original intention, unvocal legislative. When dealing with certain emergency situations, formal jurisprudence would be the realistic approach, as it remains close to constitutional values, but also weighs other possible solutions. Instrumental jurisprudence, quote, refers to approaches of constitutional interpretation which are basically centered upon weighing the respective interests of individuals, groups, and states before adjudicating accordingly. Typically, the weighing of interests is done by establishing means and relationship. The accuracy of the mean chosen to reach a legitimate constitutional end will be measured, taking into account the opposite interests involved. This operation frequently implies some kind of social or logic jurisprudence, that is to say, concrete analysis of social facts, more or less inspired by social science. Unquote, page 360. Instrumental jurisprudence is basically getting views of interests and individuals, groups, and states before coming to a decision. Notably, both sides are taking into consideration before a conclusion is made. Instrumental jurisprudence also views itself as being value neutral and objective. And finally, the jurisprudence of values, quote, is an interpretive method based on constitutional ethical convention constitutional values and fundamental principles are constructed according to pre-existing even supra-constitutional hierarchy of values, which guide the judge in the task of constructing and applying constitutional rules. The jurisprudence of values rejects any type of legal reasoning claiming to be free from values. Unquote, page 317. Essentially, jurisprudence of values is based on constitutional ethic of conviction meaning its views do not change. Constitutional values and basic principles are put together where beliefs are put in order of importance. This jurisprudence denies any sort of legal reasoning which leads to fear values. These three ideal types only represent the thought process of constitutional or Supreme Courts that deal with the area of human rights. With that being said, the process of the case of Suresh will show the effect of formal jurisprudence and that within emergency cases and situations, formal jurisprudence is the best approach. The facts of the case are as follows. Since 1991, Convention of Refugee in Canada was obtained by the federal authorities from 1991 to 1998 on suspicion that he was a fundraiser and member of the Liberation Tigers of Tamil, ELAM, considered by the Canadian government to be a terrorist organization. The Minister of Citizenship and Immigration commenced deportation proceedings against which Suresh urged vigorously in fear of being submitted to torture if he was deported by force to Sri Lanka. This deportation certificate was upheld by the federal court, trial division, and by the federal court of appeal, and Suresh was nevertheless released from detention from 1998 onwards, though under strict terms and conditions pursuant to a decision of the federal court. Looking at the facts of this case, it is to be noted that international law played a major role, especially when international law coincided with the Canadian Charter. For that, take a look at international law. The Supreme Court believes international laws should be taken into consideration less relevant to Canadian law. But the courts also instantly acknowledge, quote, in seeking the meaning of the Canadian Constitution, the courts may be informed by international law, unquote, page 324. Meaning the courts cannot make decisions strictly on international laws due to the fact that they may not stay true to the Charter, unless involved with terrorism and is a threat to national security. Quote, court sees no conflict between Section 53, Subsection 1 of the Immigration Act 40 and international human rights laws. Section 53, Subsection 1, provided that no convention refugee or person denied refugee status under the convention shall be removed from Canada to a country where the person's life or freedom will be threatened for reasons of race, religion, nationality, membership in a particular social group or political opinion, unless the person is or engaged in terrorism and, according to the Minister's opinion, constitutes a danger to the security of Canada, unquote, page 324. For this, when that person is involved with terrorist organizations, he or she is putting citizens' lives at risk. And handling such a delicate case at issue, it is essential that the main concern be keeping society safe. When taking into account the international law, it is essential to be reminded of a refugee can only be deported under exceptional circumstances. Those exceptional circumstances of an individual who is an individual who is involved with the terrorist group. But understand the Suresh case, one must also take into consideration the Anani, a veteran refugee since 1991, was believed by the Canadian authorities to be acting on behalf of the Iran Secret Services, himself considered to be a terrorist organization. The evidence showed that after being granted the refugee status, Anani had made a trip to Europe with a false passport and met secretly with an Iranian official. On his return to Canada, Anani was interrogated by the Canadian Secret Intelligence Service, then arrested on June 17, 1993, and kept in custody pending his deportation. The deportation ruling relies on two questions: whether the individual is a threat to national security and whether he will face a high risk of torture once deported. The first question is straightforward, as if you are involved with a terrorist organization, he poses a threat to national security, and in Anani's case, he poses a threat to the safety of Canada once he entered and became a convention refugee. The second question is solely based on the fact that once a judicial decision is made, the court may intervene only if the minister's decision is not supported on evidence or fails to consider the appropriate factors, unquote, page 320. In this case, the minister's judicial decision was that Anani would pay deportation. The reasoning for that, the Supreme Court had decided that the minister's decision was that Anani's case was reasonable as it posed a threat to national security in Canada. We take from these two cases formal jurisprudence. Formal jurisprudence approach to these cases is for here, there are two quotes by my standards to you. First is from Lord Huffman following the tragedy of 9/11, as he added to his postscript to his speech. Quote, I wrote this speech some 3 months before the recent events in New York and Washington. They are a reminder that in matters of national security, the cost of failure can be high. It seems to me underline the need for judicial arm of government to respect the decisions of ministers of the ground on the question of whether support for terrorist activities in a foreign country constitutes a threat to national security. It is not only the executive has access to special information and expertise where these matters are concerned, it's also that such decisions with serious potential results for the community require legitimacy, which can be conferred only by entrusting them to persons reasonable to the community through the democratic process. If the people are to accept the consequences of such decisions, they must be made by persons who their people have elected and whom they can remove. Unquote, page 328.
1 minute warning.
Basically, the question of whether support for activities in a foreign country constitutes a threat to national security remains solely on citizens. As citizens should elect leaders they want to make these types of decisions. This being what we have founded in the democratic process. In essence, an evidence of specific danger to the foreign country is no longer needed as Canada's security is more essential. International conventions must be thought of less due to 9/11, as previously it would be wise to think terrorism in one country did not conflict with another country. But since September 11, 2001, there's no longer the right to think this way. This can be seen in previous attacks, such as the bombing of Air India, where there was 3 countries involved: Canada, England, and India. And it's not to say that with the formal jurisprudence approach, these attacks would have been prevented, but with the formal jurisprudence approach, the chances are greater that the tragic event would never happen. Lives could have possibly been saved, bodies would not be gone undiscovered in the Atlantic Ocean, and families of friends would have still not lost loved ones. On the side of liberty and security, the question will always draw controversy. But since the attacks on September 11, 2001, the idea to keep a nation safe is important as never before. Since 9/11, everyone is scared of the thought that anything can happen at any time.
Thank you.
Does the Crown have any further arguments? Yes, Your Honor.
May I proceed? My name is Sabrina Manson. I am representing the Crown, and today I will be discussing the case of R versus MN. In this case, the main issue at point was whether the disclosure of information poses a threat to international relations and the prosecution of individuals accused of offenses against our laws. Disclosure of information is basically to obtain evidence and not giving it to the opposing side. Before I proceed with the details, I would like to state what the Canada's Evidence Act, Section 38 to 38.16 states. Section 38 scheme provides a procedure to govern the use and protection of sensitive or potentially injurious information. Those expressions are defined as in the Act as follows. Potentially injurious information means information of a type that if it were to disclose to the public, it could injure international relations or national defense or national security.
Sensitive information means information relating to international relations or national defense or national security that is in the possession of the government of Canada. Whether originating from inside or outside of Canada, it is the type that the government of Canada is taking to measure the safeguard. In June of 2006, 18 people were arrested in the Greater Toronto area on the suspicion that they were plotting terrorist attacks. The suspects were alleged to have conducted terrorist activities and taken attacks in Ontario, to have amassed weapons, and to have made plans to storm Parliament, where they intended to behead politicians and detonate truck bombs in several locations. The accused were initially brought to the attention of the Royal Canadian Mounted Police by the Canadian Security Intelligence Service. On a number of occasions, the CSIS provided the RCMP with information that had been gathered through surveillance and the use of informants. The June arrests were preceded by more than 6 months of investigative work done by the RCMP's Integrated National Security Enforcement Group. This appeal concerns the potential conflict between two fundamental obligations of the state under a system of government. First, to protect society by preventing the disclosure of information that could pose a threat to international relations, national defense, or national security, and second, to prosecute individuals accused of offenses against our laws. The issues over here were the constitutional law validity of the legislation. Section 38, Scheme of Canada Evidence Act, granted jurisdiction to federal court to determine questions of disclosure of information pertaining to international relations, national defense, or national security. Whether Parliament's decision to limit Superior Court from determining those questions intromiscibly invades court jurisdiction of Superior Court, and whether Canada's Evidence Act infringed Constitution Act Section 96. And the second issue at point was whether the right to life, liberty, and security of the person under the Charter, in Section 38, Scheme of Canada Evidence Act, granting jurisdiction to federal court to determine questions of disclosure of information pertaining to international relations, national defense, or national security. Whether attribution of jurisdiction to federal court impedes the ability of Superior Court judges to ensure and conduct a fair trial. The question here was whether the Canada's Evidence Act, Section 38 to 38.16, infringed Canadian Charter rights and freedoms of Section 7. In the case of R versus M, the court had made a final decision stating Section 38 does not violate Section 96 of the Constitution Act 1867 because it does not prevent a court's power to remedy abuses of process. Section 38 of the Canada Evidence Act is in place to protect society by preventing the disclosure of information that could pose a threat to international relations, national defense, or national security. And second, to prosecute individuals accused of offenses against our laws. The Anti-Terrorism Act speaks for these laws, as they are enforced for the safety and security of our society. Section 38.06 affirmatively requires the federal court judge to consider the public interest in making disclosure, along with what conditions are most likely to limit any injury to international relations or national defense or national security. In order to justify an infringement of Section 96 of the Charter, we use the test set out by Dixon J. in Re-Residential Tenancies Act 1979 as developed in the subsequent cases. In brief, the test asks 1. Whether the power conferred broadly conforms to a power or jurisdiction exercised by a superior district or county court at the time of confederation. 2. If so, whether the power is a judicial power. And 3. If so, whether the power is either subsidiary or ancillary to a predominantly administrative function or necessarily incidental to such a function. Applying this test, there is no violation of Section 96 in this case. The examination under Residential Tenancies Act 1979 ends at the first question, and there is no infringement of Section 96 under the test. Further, while it is true that a superior court's ability to decide the constitutional issues that come before it forms a part of its core jurisdiction, the issue here is not properly characterized as the authority of the superior court to protect the integrity of its process. Instead, it's regarding the issue that relates to authority in relation to disclosure of material for which the security exemption is claimed and public safety is an issue. In addition to that, the Supreme Court of Canada has also claimed that Section 7 of the Charter, which is everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice, has not been infringed by 38 to 38.16 of the Canada's Evidence Act. The federal court judge's sole concern under the scheme is the protection of public interest in sensitive or potentially injurious information. If the federal court determines the disclosure of the information at issue would be injurious to international relations or national defense or national security, then disclosure will only be ordered by the court if it's in the view of the public's interest. If it's in the view the public interest in disclosure outweighs the public's interest in non-disclosure. It is in the best interest of the public to disclose information and prevent threats that may be opposed to national relationships and security. The final decision that was made by the Supreme Court in the past was in favor of the public interest in safety. It is our responsibility to bring to your attention that public safety is a biggest concern. It is under our provision to keep these acts established and prevent them from being struck down, since they protect our citizens and save them from being exposed to terrorist activities. When it comes to public safety, one of the most famous cases and recent cases that can be looked upon is the case of Omar Khadr, who was pleaded guilty in 2010 to 5 war crime offenses. 1. Spying, and then conspiracy, providing material support, attempted murder, and death of U.S. Sergeant Christopher Spear, who was fatally wounded in a battle in 2002. An individual like Omar Khadr can be a huge threat to public safety. An individual who was influenced by his father and was tied up in national terrorist activities is a major concern when it comes to the welfare of the public. Omar Khadr, who had in the past committed crimes which have been proven since he had the concept of actus reus and mens rea. Actus reus, the criminal act, a guilty act or deed of the crime, and mens rea, guilty mind. Mens rea indicates the mental element or intent required for the commission of a criminal act. Several criminal state of mind would include intention, knowledge, recklessness, willful blindness, and fraudulence and malice. A young individual who had the ability to refuse these acts and still supported these terrorist activities can pose threats to the society again. He himself has committed these acts, and it is under the power of the supreme law to prevent these acts from happening in the future and preventing such tragedy from happening. In all words, the Anti-Terrorism Act should not be struck down. It is present to obtain a peaceful Canadian society and prevent terrorist activities from breaking out. It is in the public's best interest to have these acts in place and there to protect society and citizens. They are justified under many sections of the Charter, including Section 7, which ensures the life, liberty, and security of an individual. The Anti-Terrorism Act should not be struck down, and it held in its place to preserve a peaceful Canada. Thank you.
Does the Crown have any further arguments?
Good morning, Your Honors. My name is Rashana Singh, and I will be representing the Crown with the Mohammed Moner Khawaja case. May I proceed? So, Mr. Khawaja was a computer programmer born in Canada who was arrested in 2004 and charged under the terrorism section of the Criminal Code. In the years leading up to his arrest, Mr. Khawaja became extremely interested in Osama bin Laden and the against the Westerners that he promoted. Now, Mohammed Roman Khaja was charged with 7 offenses and convicted of 5 under the terrorism section of the Criminal Code. The legitimate purpose of the terrorism section of the Criminal Code, according to the government, is to provide means by which terrorism may be prosecuted and prevented. Now, that's section 83.28. And also, for the provisions and the sections that I will be listing, you may look at the appendix of the full case for reference. Now, the terrorism section of the Criminal Code is not to punish individuals for innocent, socially useful, or casual acts may indirectly contribute to terrorist activity. Now, some of the major offenses that he committed were possessing an explosive substance with the intent of enabling a terrorist group to endanger others. So he was working on the development of a detonator and keeping an explosive substance. Those acts of mens rea had to be present. Section 83.03, now getting into the sections of the Criminal Code, which is providing or making available properties or services for terrorist purposes. Section 83.18, participating in or contributing to the activity of a terrorist group. Section 83.19, facilitating a terrorist activity. And Section 83.21, instructing people to carry out an activity for a terrorist group. Now, my friends have also claimed that the definition of terrorist activity under the Criminal Code infringes the Section 2A, freedom of conscience and religion, 2B, freedom of expression, including freedom of the press and other media of communication, and 2B of the Charter, freedom of association. It is also claimed to violate Section 7, the right to life, liberty, and security of a person. Now, under the terrorism section of the Criminal Code, it specifies that in Section 83.01, subsection 1, subsection B, subsection 1, subsection A, a terrorist activity must be an act or an omission, which is an error, committed in whole or in part for a political, religious, or ideological objective or cause. Now, the two main arguments or issues I'm going to be focusing on is that appellants claim that in Section 2B, freedom of expression, including freedom of the media or press and media communication, is infringed, along with one of the most controversial charges underneath the Criminal Code, the terrorist section, which is Section 83.18, participating in or contributing to the activity of a terrorist group. Firstly, I would like you all to turn to page 14 and 15 of the full package of Mr. Quadra's case. There you will find core evidence which displays why he was charged under the terrorism section of the Criminal Code. I will highlight to you some of that evidence. Firstly, Mr. Quadra designed a remote arming device, a detonator for explosives that he referred to as a hi-fi digi-monster, and offered to smuggle it into the UK and train UK cell on its base. The appellant traveled to Pakistan alone with Cam, and Cam is the leader of a terrorist cell based in London, England, who was convicted, along with many others, of a plot to bomb targets in the UK and other places in Europe. He also attended Babar's small arms training camp, and Babar is an American of Pakistani descent who eventually pled guilty in New York to 5 counts of providing material support and resources to Al-Qaeda. He made his parents' home in Pakistan available to them and the Bros. And who the Bros are people who commit to violence in the name of Islam. He suggested that the members of the UK group travel to Canada for weapons training. He also suggested that Cam, through email, that a supporter of the Cam group, he sent to Israel on a suicide mission. Now, there were many emails which demonstrated in detail to the appellant's ideological motive and commitment to the violent jihad, and to his acts in Canada and elsewhere to further jihad-inspired activities. Now, since he had the ideological motive and commitment, it does not violate Section 7 of the Charter. My friends also challenged the constitutionality of the Anti-Terrorism Act, as they believe that the motive clause will produce a chilling effect on the expression and beliefs and opinions, and thus violate Section 2B of the Charter. However, within certain limits, Mr. Quadra certainly has a right to express his views, but that does not include the right to act upon them, which is exactly what he was caught doing, designing and building remote detonators for bombs. The free speech protection offered or threats of violence. Violence expressions and threats of violence fall outside the Section 2B guarantee as it challenges the rule of law. Now, the critical right at issue is freedom of expression because the 2B argument, according to the Chief Justice within the Supreme Court document, has been framed to be the goddess of the Charter infringement claims. Since freedom of expression is not infringed on the case, there is no basis to challenge that freedom of religion and association are infringed. Now, according to the appendix, a terrorist activity is defined as an act or omission that intentionally causes death or serious bodily harm, endangers a person's life, causes a serious risk to health or safety of the public, or causes substantial property damage likely to result in bodily harm. So that is from Section 83.01, subsection 1, subsection B, subsection 2, subsection A, subsection B, subsection C, and subsection D. These acts and threats to commit them constitute serious violence or threats of violence and hence are not protected under Section 2B. Therefore, committing a terrorist activity, assisting in the commission of a terrorist activity, enhancing the ability of others to commit a terrorist activity, and instructing others in the commission of a terrorist activity are expressive activities. However, violent acts are not protected under Section 2B, an example being from the Irwin toy case, which was the company that claimed that there was a Section 2B infringement, but there wasn't. Section 2B protections do not apply to the terrorism section of the criminal code. Now, the criminal code treats counseling, conspiracy, or being an accessory after the fact to be intimately connected to violence and to the danger to society and such violence represents. As a result, counseling, conspiracy, or being an accessory after the fact in Section 83.01, subsection 1, subsection B, subsection 2, A, B, C, and D can find no protection under Section 2B. Therefore, the purpose of the law does not infringe Section 2B, freedom of expression, or Section 7. Now, the effect of the mens rea is to exempt those who may innocently assist terrorists or who do so for a valid reason. Quadra had the intent to enhance the ability of the terrorist group to facilitate and to carry out terrorist activity. The evidence within the full package displayed that the appellant himself viewed the violent jihad he was committed to as unlawful. Moreover, the appellant's actions were directed at supporting terrorist activities inside and outside of Afghanistan. Now, I will be discussing one of the controversial criminal code charges that Mr. Quadra was charged under, that is Section 83.18, participating in or contributing to an activity of a terrorist group. Now, Quadra did not only participate in or contribute to terrorist activities knowingly, but also his actions had been for the purpose of enhancing the abilities of a terrorist group to facilitate or carry out terrorist activity. Now, the provision, Section 83.18, is meant to criminalize conduct that presents a real risk to Canadian society. Now, let's talk about the reasonable person. So, if a reasonable person was to see the evidence, was to see his actions, they would say that he's enhancing the abilities of a terrorist group and he will be guilty. Now, therefore, the provisions of the criminal code under the terrorism section 83, which Mr. Quadra has been charged under, do not violate Section 7 or Section 2 of the Charter. The evidence within the full package discloses that the appellant was determined to help the counter perpetrate a number of acts of mass violence against civilian and military targets, which is obviously violent. He offered training of electronics to a terrorist leader, built devices intended to trigger explosives, and went to Pakistan to train for combat in Afghanistan. His emails showcased that he encouraged and applauded the violent jihad. What was frightening was his email, which in positive terms spoke about using a troublesome person as a suicide bomber in an Israeli nightclub. As a reminder, the past Supreme Court decision before this review was in the Crown's favor, and it was a very restrained decision concerning that no laws were changed, as you all stayed with the law. Again, the purpose of the Anti-Terrorism Act is to provide a means by which terrorism may be prosecuted and prevented, and it is showcased within this case to why such an act is needed, which is to protect harmful people like Mr. Kawaja from Canadian society. Thank you.
Good morning, Your Honors. My name is Megan Cooling. I am representative of the defense, along with my colleagues Harshdeep Neb, Timothy Pam, Savvy Perry, Devin Williams Floyd, and Cindy Tran. The reason that everyone is in the courtroom is due to the Anti-Terrorism Act, which I will refer to as the ATA. May I proceed? This act is what protects Canadians from terrorist activities. My friends of the crowd are arguing that there should be no changes to the Anti-Terrorism Act, but we at the defense believe that there should be changes to the act since there are many violations occurring. Today, the cases of R versus Kawa, Chinguacousy versus Canada, and R versus Ahong will be brought up, and the defense shall outline how these cases have been violated, as well as articles like the War on Terror. Is infinite detection of terrorist suspects really constitutional, and national security surveillances in an age of terror, statutory power, and charter limits will also be outlined by the defense. We believe that in some parts of the ATA should be read out, as well as other parts should be read in regards to the cases. Other changes include changes to Immigration and Refugee Protection Act and Section 38 of the Canada Evidence Act. There are also violations from the Charter of Rights and Freedoms within the ATA, specifically Sections 2, 7, 8, 11, and 15 are violated and they should be compensated. We of the defense ask you to listen carefully to our arguments and ask for an open mind on the information that is presented to you. We hope the Supreme Court will be able to make a decision fairly.
Does the defense have any further arguments?
Yes, Your Honor. My name is Megan, and the article that I will be focusing on is National Security Surveillances by Stephen Penny. May I proceed?
You may proceed.
So, national security surveillances, what are they? Well, they're surveillances that protect the country from terrorism attack. In Canada, the National Security Agency's communication surveillance powers rarely have been prosecuted, but as more terrorists are being prosecuted, the courts have to decide whether Section 8 of the Canadian Charter of Rights and Freedoms has been violated. There are three specific groups that are talked about in this article, one being the police, another being the Canadian Security Intelligence System, or CSIS, and the third one being Communication Security Establishment Canada, or CSEC. There was a review, according to Penning, that there are two constitutional infirmities, which are allowing police to conduct surveillances without investigative necessity, and the second being allowing CSEC to intercept communications without judicial authority. Due to these two constitutional infirmities, there is a violation in Section 8 of the Charter. There are powers that are granted to each government agency that violate the privacy of innocent Canadians while providing no advances to national security. Due to recent terrorism, many new laws and legislation that have been passed that enhance surveillance abilities of law enforcement and national security agencies in Canada. But these enhancements diminish liberty, privacy, and equality of non-terrorists. For Section 8, the courts have to balance our privacy against combating threats to public. There needs to be reasonable and probable grounds to believe that an offense did occur and that there was evidence to be found at the place of search so that the judge can authorize the invasion.
I would like to, at this point, bring in a previous case precedent. This is the case of Hunter and All versus Southland Inc. In this case, for those who do not know, the government, or Hunter, examined all documents in Southhand's business premises, but of the new wing. This did violate Section 8 of the Charter, and was the first case heard by the Supreme Court for this. The court also states that agents wanting to do the search must show that there is no other option, which is also known as investigative necessity. Advances in technology have complicated the application for reasonable grounds standards, which, according to Pennant, I'm going to ask you guys to refer to the article, page 251, the last paragraph, and page 252, the first paragraph, that national agencies should not have to demonstrate that surveillances will find evidence that will prove an offense has been committed. So I'm going to be talking about the police, and they're one of the more focused part of this article. So the police, what they do is they investigate the national threats. And since 9/11, there's been many amendments that have made it much easier for the police to use their power in terrorism cases than any regular criminal case. Part 5 of the Criminal Code, which is the part that prohibits intercepting private communications, also applies to watching a person of interest via either a video camera or any other electronic device that you can watch someone. The police have to obtain a warrant or an authorization from a judge, which the requirements are more onerous than an ordinary search warrant. Similar to ordinary search warrants, evidence found without it can be excluded under Section 24(2) of the Charter. Authorization, though, can only be obtained by Superior Court judges and must only be used to further an investigation. The application for this also has to have written consent from a responsible minister, and there has to be no other reasonable grounds to find evidence. This can be satisfied by demonstrating that normal techniques are unlikely to succeed, which is investigative necessity. In 1997, Parliament removed investigative necessity due to gang violence, and later in 2001, after 9/11, they did the same thing again, but this time it was in response for terrorism. In 2001, 2 more sections were added, which were changing the criminal organization and terrorism investigations by allowing the interception period to go from a maximum of 60 days up to now a year. It also allowed investigators to extend the date without providing evidence that the investigation was continuing. At this point also, I would like to bring another case precedent in which is the case of R versus Dewar. And in this case, Justice Latore stated, if the state was free at its sole discretion to make permanent electronic recordings of private communications, there would be no meaningful resident to our right to live our lives free from surveillance. He also states, a society which exposed us at the whim of the state to the risk of having permanent electronic recordings made of our work every time we opened our mouths would superbly equipped to fight crime, but would be one in which invades privacy and gives it no longer any meaning. Due to the lack of privacy, citizens of Canada might resort to more expensive communications like payphones to remain anonymous rather than using cell phones, which are less costly and not private. Privacy also has to be balanced with law enforcement. No court, though, has yet considered investigative necessity an exception for terrorism offenses, but lower courts have, however, concluded that it is not constitutionally required. Without investigative necessity, surveillances may be justified by reasonable grounds, that evidence for the events will be uncovered. There's also a greater risk that the police will unfairly conduct surveillances on Muslim and Arab Canadians, and this is racial profiling of their backgrounds. So CSIS is another organization which it can only conduct investigations. They have to be authorized to investigate the place that they are interested in searching and to be able to enter it to obtain evidence. This protects privacy, which is main part of Part 5, Part 6 of the Criminal Code, but there's also an act for CSIS called the CSIS Act, in which CSIS can make its applications to get warrants to search the place, and it can only be approved by a designated official. This act offers less protection than Part 6. The act has no requirement to inform targets or to report to Parliament, and the interceptions may last up to a year. The application for the warrant only requires reasonable grounds that the warrant will allow CSIS to investigate a threat to Canada, and secrecy in this organization is a key problem. CSEC is another government organization, and this was established in 1975 but was kept a secret until 1983. It also operated without a statutory mandate, but in 2001 this changed. It was given a part of the National Defense Act, which became its mandate. Its purpose is to collect intelligence like foreign communication, but it's also prohibited from intercepting communications within Canada. Like CSIS, this has no notification needed, and Section 8 could be violated if they intercept any communications within Canada. So if you were having a conversation with someone from England or elsewhere and they were listening, it would violate Section 8. As well as the warrants that are issued here in Canada, they have no effect in the country of interest, but Parliament can order an invasion to that country, which would work. And, yeah.
Does the defense have any further arguments?
Yes.
My name is Christian, and I'm representing the defense, and I'll be talking about Chinguacousy versus Canada. May I proceed?
You may proceed.
Now, first of all, I'd like to talk about what is a terrorist. Now, according to the dictionary, one who leads an armed group that kills civilians as a means of political intimidation is a terrorist. Now, society definition is if you're a colored person or a Muslim religion, you are a terrorist. Now, my case, Chinguacousy versus Canada, talks about that Chinguacousy, he was a refugee who was held on a security certificate. Those certificates allowed individuals, non-Canadian citizens, to be deported. If they believed to be security threats to international national security, this case is important because the Supreme Court ruled that security certificates were under certain sections unconstitutional and violated certain charter rights. Again, they had no proof on it, they just assumed. Now, based on my research, Abdul Chinguacousy did become the permanent resident of Canada. He was arrested by the Canadian government under security certificate, and he was held on security certificate. Evidence upon arresting him was that he was trained in a Soviet jihadist camp in Afghanistan. Now, the government didn't like the fact that he went to Pakistan for a short visit. And when he was in that camp, jihadist camp, the CSIS and the court thought that he could have been trained in rocket launchers, grenades, and assassinations. They also assume the fact that he might have something to do with 9/11. Now, what I want to say is, why would you assume something like that? You have no solid proof, so first of all, get some proof, and then, tell the person that, you're guilty. Next person I'd like to talk about is Mohammed Harkat. He also was a permanent resident of Canada. He was arrested because he was under suspicion that he had something to do with terrorism. There was no proof, they just assumed. CCS also assumed that he entered Canada as a sleeper agent or a special spy for Al-Qaeda. After being released, he was charged under the rights of Community Charter Rights, Section 7, 9, and 10. Also, they charged him with the Immigration and the Refugee Protection Act, Section 33, Rules of Interpretation, Section 77, Referral to Certificate, and Section 85, Person who may act as a special advocate. Now, again, they had no proof on him, they just assumed. Next, I'd like to talk about Hassan al-Mary. He was also a refugee when he came to Canada. They confronted him with the fact that he had pictures of IBM Catalog, Osama bin Laden, and Muhammad Ali in his computer. Now, IBM Catalog and Osama bin Laden were like friends, so they are big terrorists. And Muhammad Ali was the Egyptian hacker that hacked the plane that crashed into the World Trade Center during 9/11. Now, what they said that they did have pictures in his computers, but what they didn't make themselves clear about is they weren't really pictures, they were BBC newspaper articles or news reports. Now, that does not mean that just because you have newspaper report articles on big terrorists doesn't mean you're a terrorist or makes you a terrorist. Now, this is not a criminal trial, so you don't need a solid proof if someone is involved in terrorism. There's only need to be a reasonable belief that someone poses a terrorist threat. This is important because the Supreme Court ruled that security certificates were under certain sections unconstitutional and violate certain charter rights. Now, I want to say that what people these days do is they just assume somebody has done this and make people believe that, but they don't prove it. So I'd like to change the fact that you're innocent till proven guilty. Now, Your Honor, I would like to make reference to the media. Looking at the media these days, that this is how the society works these days. If you see a kid being attacked by a dog, and a Caucasian male saves the kid's life, next day the newspaper shows that a hero saves the day by killing the dog or making the dog go away and save the kid's life. But if a non-colored person or a person from a Muslim religion does the same thing, next day news report shows that a terrorist ruined the day by killing the dog who was happily playing with the kid. Now, I'm not saying that all Muslims are terrorists. That's not true. There are some nice Muslims out there. That's all I know.
Yes, Your Honor.
Good morning, Your Honor. My name is Timothy Pham, and I'm representing the defense. Today, my case will be about indefinite detention for terrorist efforts to the Constitution. May I proceed? An illegal order that devotes us to the rule of law and the protection of one's rights. One would believe that circumstances would be mandatory to justify indefinite detention of a person who has never been convicted of an offense. However, Under the Canadian Charter of Rights and Freedoms, one would expect such a proposal is evidently inconsistent with the principles of fundamental justice and understandable under Section 1, only in an extreme emergency. As you may know, Mr. Adel Charter, which I will be referring to as Mr. C, a Muslim of Moroccan descent, has been detained in Montreal for being a terrorist suspect who has been held for 2 years along with 6 years living under restrictions. In this case, the court dismisses Mr. C's Section 7 claims and does not reach the question of whether any outstanding circumstances approve his scheme. As a citizen and individual, Mr. C felt his rights were immediately violated because his life, liberty, and security was not guaranteed by Canadian governments. Now, the Immigration and Refugee Protection Act, which I will be referring to as the IRPA, stated that several grounds on which non-citizens of Canada are prohibited from stepping into Canada. One of the grounds is, in fact, is a risk to security, which also includes engaging in terrorism and other plots of violence, or being a member of an organization that there are reasonable grounds to believe engages or has engaged or will engage in potential acts of terrorism and other acts of harm and violence. Thus, this can only be an assumption to immigrants believing they are in contact with a terrorist group or alliance, which Canada cannot afford to take chances. Judging by what the IRPA said, referring to page 236 of the indefinite detention article, they stated, and I quote, an admissible non-citizen who is in Canada may be deported. In other words, anyone with non-Canadian citizenship has a slim chance of staying within Canadian soil. Finishing the quote. And I quote, where the government wishes to deport someone on security grounds, it may invoke security certificate procedure, end quote. This can only mean that anyone that is to be a terrorist suspect may be held by the Canadian Secret Intelligence Service, otherwise known as CSIS, and could cause permanent deportation. In other words, detain and deport. The only good the security certificate procedure provides is that by doing this procedure, future potential terrorist plots may be prevented with the purpose of the justice system becoming less tolerant and or having the entire Canadian society be more aware of terrorists. But how can anyone guarantee this works 100% of the time without neglecting one's rights and freedoms? Your Honor, I'd like to make a reference of these 4 case precedents, such as Hussein al-Amri, Muhammad Arafat, Mohammed Jalal, Mohammed Zeki Majid, including Mr. Charter. Including they were known as the Secret Five. The reason of the code name Secret Five due to the common fact that they were all detained for being a terrorist suspect. However, there was no evidence to prove that any of these men, by CSIS, that have been affiliated with the terrorist plot. These men were only held for years without being charged. Now, the secret evidence, which is in the slideshow, the secret evidence of these 5 men is just one big assumption. An assumption, in fact, that was made entirely after the 9/11 incident back in 2001, where North America believed that anyone of Muslim religion may or has been in a terrorist group. The violations were, the charter violations were Section 7, 9, 11B, D, and Section 15 of the legal order. Under Section 7, these men were not guaranteed any of these before being detained. These men were accused of being a terrorist suspect when they themselves have not caused any harm or violence to anyone within their years living in Canada. In fact, none of these men were convicted of committing any crime. These specific individuals' lives were taken away for a long period of time and had to rebuild themselves because of the misunderstanding made by the government. Section 9 of the Charter was violated according to these men in the case precedents. They were immediately detained for no particular reason. The only reason Canadian forces had against them was that they believed all these 5 victims were suspect terrorists. But clearly, the Canadian government failed to present any real evidence. Section 11B provides that these men deserve a fair trial due to immediately detained for being suspects. However, this was thrown out for only the reason that they believed to be terrorists. And sadly, Canada does not wish to speak on behalf of anyone who is a suspect terrorist. Section 11B would guarantee that these men were in fact innocent until proven guilty, but it was clear by CCs themselves that it couldn't be proven that these men committed or aided any one of terrorist plots. Section 15A of the Charter, these individuals should have not been detained, all due to the government's lack of evidence provided and their assumptions. However, yes, there was no evidence of racial profiling, but there was an assumption of these men being terrorists due to the 9/11 caused by Al-Qaeda back in 2001. Why go to the trouble of having secret evidence? But because these men were of Muslim religion, this does not mean they were part of the attack nor had any affiliation with the terrorist groups. Now, the conclusion. The Anti-Terrorism Act, which is referred to the ATA, lacked evidence who were trying to prove these men were terrorist suspects. The IRPA and CSIS violated many of these individuals' guaranteed rights, such as Section 7, 9, 11B, and D, including Section 15, due to their assumptions of what they believe a terrorist may look like. And because of this, lawsuits were made against the groups working under the ATA. The IRPA scheme of security certificate procedures fails to provide real evidence of who is a terrorist. In this case, along with the case precedents, these men have been residents of Canada for more than a decade. Yet the IRPA refuses to acknowledge them as citizens. The ATA should definitely be struck down, if not, read out some laws that do not help the justice system of Canada. By having privileges beyond the average citizen. Anyone working under the ATA or the National Emergency Protocol is given privileges beyond the average citizen, thus allowing indefinite detentions to be laid upon foreign nationals. However, if indefinite detention still remains the choice of the IRPA or CSIS, it should be more common to allow a lawyer to speak with their client. Now, a question to the court is, why does Canada advertise ourselves as the land of the free when we cannot guarantee anyone's rights and freedoms? That's the other one.
Any other further argument? Yes, Your Honor.
Good morning, Your Honor. I'm Sam Rupai, S-A-B-I-Rupai, I represent the defense, and I have reviewed the article of War on Terror, Constitutional Governance in a State of Permanent Warfare of West Ethiopia. Proceed, Your Honor.
Proceed.
Canada's response to 9/11 was the Anti-Terrorism Act and the Public Safety Act. A secondary package includes restrictions on public protest, plans for increased surveillance of private communications, monitoring of individual travel through a Big Brother database, changes in provincial legislation, proposals to create a national identity card, and numerous changes in the law and practice of immigration and citizenship. But by what principles should security actually be organized? Wesley Beer has stated in his article that 5 principles should guide lawmaking. 1. All laws should seek to attain minimal infringement of civil liberty. 2. There should be maximum clarity of definition regarding powers conferred, restrictions imposed, and offenses created. 3. All exercises of governmental powers should be accountable, visible, and reviewable by the ordinary courts in the ordinary ways. The core constitutional principle of responsible government requires clear and effective channels of political and legal accountability. 4. Secrecy should only be tolerated in the smallest possible zone, only as absolutely essential and only for limited duration. Power exercised in secret is never accountable. 5. For extraordinary powers that are invoked in time of perceived crisis, this should be of limited duration, renewable only by full reconsideration and reenactment by Parliament. The Canadian Anti-Terrorism legislation fails on all these counts. Furthermore, the Anti-Terrorism Act provisions for preventive detention compel testimony before the investigative hearing, and greatly enhance powers of governmental proposed sustained criticism on the ground that these serious measures violate Canadian values. Section 83.01 of the Criminal Code defines both terrorist activity and terrorist groups. The definition of terrorism involves an act or mission motivated in whole or part by political, religious, or ideological purpose with the primary intention of either intimidating part of the public regarding security, economic security, or compelling any government person or organization inside or outside Canada to do or not to do any act. But it should be accompanied by one of the five secondary intentions, which are causing death or serious bodily harm to a person by use of violence, engaging a person's life, causing serious risk or safety, causing substantial property damage of a sort likely to result in serious bodily harm, or causing any serious interference with any essential service, faculty, or system. To add on, the new terrorism offenses are not so defined. Perpetrating instead prohibit all acts or missions committed in or outside Canada with the intent of compelling a person or a government or domestic or international organization to do or refrain from doing any act. For example, under the Anti-Terrorism Act, Canadians who supported descendants within Iraq prior to the 2003 US invasion would have been acting in contravention of our anti-terrorism law, even if they did so by aiding the US officials. Let's talk about terrorist groups. A terrorist group is an entity whose purposes or activities include carrying out or facilitating any terrorist activity, or an entity listed by the Governor and Council on the advice of the Solicitor General. Under Section 83.18 of the Criminal Code, it states that everyone who knowingly participates in or contributes to indirectly or directly any activity of a terrorist group for the purpose of enhancing the ability of any terrorist group to facilitate. The offense may be committed even when no terrorist activity is even being carried out. The individual's contribution or participation may not have actually enhanced the group's action, and the person may have not known of the specific nature of the group's intent. Furthermore, the distinction between good guys and bad guys is not actually clear, and charities lack the intelligent capabilities required to ensure that none of their resources would assist someone could be considered a terrorist group. Might a Canadian charity providing financing or resourcing to a terrorist group face sanctions even though the entity was not considered a terrorist group at the time? The Anti-Terrorism Act comes down to ill-defined powers on police officers and executive branch of government. The government has no direction with the Anti-Terrorism Act, and the police officers do not know how to enforce this law. Asked by Senator Karen Fraser to explain the reasonable grounds that might justify the use of preventive detention, RCMP Commissioner Zachary Dudley responded saying, and I quote from page 283 of the article, "Obviously, what you have just described is a lower threshold than what we have normally used to see in this country. We are in the active discussion about what this means because the devil is in the devil, and as we know, it is easy to read, but it is how we apply and how we interpret this which will determine how this really works." But RCMP Commissioner Zachary Dudley saying this, it clearly states that the Act provides no useful guidance whatsoever. I'd also like to mention the Air India bombing. The Air India bombing occurred in 1985, killing 329 victims. The Anti-Terrorism Act was not enacted after this tragedy. This incident was only brought back into the spotlight when 9/11 had occurred. The families of the Air India bombing victims all support the Anti-Terrorism Act and preventive measures, but why? It's because this is their emotional response. The families want anything they believe to prevent terrorism, even if it contradicts the rule of law or fails the oath test, or even if it contradicts Canada's very own constitutional values. These victims played a role in shaping the Anti-Terrorism Act, but this war was their emotional response to a tragedy, not their reasonable response. We are left with the unfortunate conclusion that Canada's new law violates the very constitutional values that render our society civil, while simultaneously failing to protect us from terrorism. The Anti-Terrorism Act does not follow the rule of law, especially regarding due process. Everyone deserves the right to a fair trial. Furthermore, the definition of terrorism is too broad to carry out the Anti-Terrorism Act. It distracts attention entirely from potentially more useful measures. This law makes us overlook other possibilities of terrorism prevention, such as security enhancing measures, better systems of emergency response, more effectively regulate both international arms proliferation and the highly dangerous materials that are in common industrial use. And that is all, Your Honor.
Does the defense have any further arguments? My name is David Maxwell, and I'm representing the defense. May I proceed?
You may proceed.
I've brought forward the case to the case today of R.V. Khwaja. From this point forward, I will refer to Mohammed Khwaja as Mr. K. The SEC has already made a decision about this case, but we defense believe that this case should be revised. After becoming obsessed with Osama bin Laden, Mr. K became in contact with a terrorist cell in the United Kingdom. This terrorist cell was later convicted of a bomb plot in and around the area of the UK. Mr. K repeatedly supported the cause, providing funds to this terrorist cell, and had a remote arming device for them. Mr. K also attended a small training camp in Pakistan. He was convicted, he was found guilty of 7 offenses underneath the terrorism act. So these 5 counts that he was convicted of include section 80.01 of the charter of the criminal code, which states that providing or making available property or service to a terrorist purpose. He was also charged under 80.18 of the section as well that states participating in or contributing to the activity of a terrorist group, and 80.19 soliciting a terrorist activity, and that's 80.21, instructing people to carry out an activity for a terrorist group. Now the question is, whether or not this verdict was unreasonable. The appellant contests that the convictions from the court were unreasonable for 3 main reasons. Number 1, the Crown failed to establish his knowledge of the UK bomb plot. Number 2, there's no evidence that he knew about the Cayenne group, that the Cayenne group was a terrorist group. This is the name of the UK bomb group. Number 3, to be convicted under 83.18, an individual must not only participate and contribute to a terrorist group knowingly, his or her action must also be undertaken for the purpose of enhancing the ability of a terrorist group to facilitate or carry out a terrorist activity, which was not proven by my friends in the original trial. Now, on to which sections should be read in and struck down or read out, because there are many offenses that have happened because of this. Number 1, section 83.18 of the terrorism section of the criminal code, subsection 2. It is written, and I quote, the conduct that a reasonable person would not view as capable of materially enhancing the ability of a terrorist group to facilitate or carry out terrorist activity. This is one way for one to be excluded from a conviction. Now my question, and the meaning of this, is what is a reasonable person? This has been brought up many times in this section of the criminal code, but no real definition of what a reasonable person is. This means that if a reasonable person thinks that one does not view the accused materially enhancing the ability of a terrorist group to facilitate or carry out terrorist activity, then the accused cannot be convicted. This is all well and great, except for the small problem of the definition of a reasonable person, as I stated before. Under the criminal code, no definition is given, nor in anywhere else is a real definition given. Is it a judge, a defense, or crown lawyer, or perhaps someone who is considered mentally sane? With such a vague explanation, it makes it very hard for this law to be interpreted and applied to cases. Hence, we the defense believe that this law should be read in. For it to be read in, we would like a real definition for a reasonable person. For this explanation, for what a reasonable person to be written in the criminal code. So from further on, we'll know exactly who this reasonable person is, and in further cases, it could be this reasonable person can help with convictions against the accused. Another section that should be amended is 83.01 of the criminal code, which states a terrorist activity is for political, religious, or ideological purpose, objective, or cause. This definition of a terrorist activity is very vague and needs to have a more specific purpose. We, the defense, feel like it should be read out, more specifically the wording of a terrorist activity dealing with a religious background. My friends of the Crown have misunderstood the definition of a jihad, which has been thrown around this courtroom many times. This word has been thrown around with any real meaning or definition given to the words of the court, so I'll help explain this to you. A jihad is not a holy war. It is but it's a struggle between two people, those who follow Islam and those who do not. There is no specific violence involved. This jihad word has been slandered by the extremists and by the Western media to make it seem like a holy war between the Middle East and the West. With this word, the jihad being thrown around, the religion of Islam has been slandered in a very negative way, making it seem that everyone or most people in this religion are terrorists or participating in a terrorist activity. We believe that this is a violation of a person's charter rights, more specifically Section 2A, freedom of religion. More specifically, as I said before, the religion of Islam, which has been slandered by individuals who are of an extremist standpoint or by the Western media. Because of this, those who follow this religion are put under a prejudice of being a terrorist or part of a terrorist act. Now on to the main dispute of this case, Section 83.18 of the Criminal Code. This section of the Terrorist Act of the Criminal Code is to charge an individual if they participate or contribute in any way in a terrorist activity or if they are part of a terrorist group. Now the main question that must be asked here is, does 83.18 of the Criminal Code violate the charter? Well, there are 4 simple steps to see if Section 83.18 indeed violates the charter. The first being a test for overbreadth. Simply put, is it constitutional? The answer is no. This law is overbreadth and unconstitutional. This law heavily violates Section 11B of the charter, the right to a fair trial. You may be wondering, how is this relevant to this case? Well, in every case except for a terrorism case, both the mens res and the actus reus must be proven. Mens res being the guilty mind, and the actus reus being the guilty action. For this, both need to be proven for a person to be found guilty. But in a terrorism case, this is not so. Only the mens res must be proven, and this can be used to prove the actus reus, whereas in other cases, they both have to be proven separately. How can we consider this a fair trial or constitutional if basic rights to a fair trial have been changed and altered in one case versus another? So as I stated before, this law is this law constitutional? The simple answer is no. The second way to view if this law violates the charter is the scope or boundary of the law. Well, this law exceeds this boundary in a very large scope. It is ultra-violent with the government. If a government can infringe basic rights to a fair trial, there's no question that this law is beyond the scope. The third way to figure out if this Section 83.18 of the Criminal Code doesn't indeed violate the charter is the objective of the law. As I stated before, this law is to charge an individual if they have participated or contributed in any way in terrorist activity. And the last is the provisions broader than necessary, or are the impacts disproportionate? Very simply put, does the ends justify the means? This law is very disproportionate because it infringes on the rights that have been given to us in our charter. If the basic rights that have been given to us in our charter have been violated, how can we consider this law to be just and proportionate? And that is all your honor.
I'm sorry for the offense, but may the Crown please relax and be more respectful to anybody who's presenting arguments.
Yes, Your Honor. Good morning, Your Honor. My name is Lee Tran, and I represent the defense, and today I am to present support the case of R.B. Alvin. May I proceed?
Proceed.
So to first start off, I would like to remind that the charter is based on the rule of law and is intention of the Constitution of Canada. All Canadian beliefs all stand on the system to protect rights and freedoms of individuals granted in a free and democratic society. We recognize June of 2006, 18 people known as the Toronto 18 were arrested in the GTA under suspicion that they were plotting terrorist attacks. The suspects would have been trained in the possession of weapons where they intended to infiltrate parliament and behead politicians. So the accused were apprehended under preventative arrest and were arrested by the RCMP and CSIS through over 6 months of investigative work. Before the trial, the Crown refuses to disclose any relevant information to the court under Section 38 of the Canada Evidence Act. If the court would please refer to page 35 of this case, paragraph 55. Yes, and I read, a major focus of the argument before us is the trial's judge's inability to access material as a subject of non-disclosure under Section 38 in cases where the trial proceeds before a superior judge court. Respondents contend and Dawson J. accepted that Section 38 interferes with the ability of superior court judges to apply the Constitution and protect sections of the rights of the accused. This is the respondent's substantive offense Section 96 of the Constitution Act of 1867 and is impermissible transferring these responsibilities to the federal court. Also, in this submission, violates Section 7 of the Charter. So here, it is challenged by the accused that Section 38 stating that it violates Section 96 of the Constitution Act, and that's also an infringement of Section 7 of the Charter, the right to liberty, life, and security of person. In the case of R.B. Ahmed, the Supreme Court of Canada has already ruled that Section 38 does not violate Section 96 of the Constitution, nor Section 7 of the Charter. However, the defense strongly feel that these infringements were overlooked and should be revised here today. Section 38 of the Canadian Evidence Act states that disclosure is important and is authorized if there is found to be no threat to national security. However, if there is national security or national threat, disclosure may only be authorized if the public interest in disclosure outweighs the public interest in non-disclosure. I would like to point out that is the public interest only important? What about the private interests of the accused? Are they not considered in these terrorist cases? There's a crucial flaw in Section 38, as I've said previously, where it's biased to only public interest and not private interest. My friends from the Crown have also pointed out that they worry that the Canada Evidence Act affects international ties. Well, what is more important? The civil liberties of our Canadian citizens or the relationships Canada has with other foreign countries? I can assume that we agree that civil liberties should triumph. If disclosure is deemed necessary, the judge has the power in order to create a remedy and protect the accused's fair rights from trial by having the information disclosed. Others of violations include Section 96 of the Constitution, which gives superior district and county courts in each province jurisdiction to hear and decide cases. However, under the influence of Section 38 of the Canada Evidence Act, concealed information will result to the judge's inability to complete the acts of material, thus interferes with the ability to apply the Constitution. Hence, invades core jurisdiction given to courts. Section 38, the scheme has also found to violate Section 7 of the Charter to accuse rights to fair trial in the disclosure of relevant information. The accused should not be in fear of not having a fair trial, even if they are accused of being a terrorist. The violation here concerns the life and liberty of the accused. The Charter, which should be able to protect the accused's rights, is infringed since the Crown has kept information from the defense. If information is not revealed, they cannot build a case, and they cannot be able to live if they cannot defend themselves in a fair trial. Without access to information, regardless if there is a trial, the trial won't be fair. Therefore, it has the Constitution. The case also seems to neglect two other very important Charter violations. They are the right to innocent until proven guilty under Section 11D of the Charter, and also equality rights under Section 15 of the Charter. This was not mentioned when the Supreme Court has decided the case previously. If the Court would please refer to paragraph 40, page 65, or page 40, paragraph 65. It states here that sometimes the only way to avoid an unfair trial is to have a trial at all. If there is no trial at all, how can the accused be presumed innocent until proven guilty? They would just be automatically assumed guilty. And the accused won't be able to be proven beyond a reasonable doubt they're innocent. It is not the Crown's responsibility, it's not the defense's responsibility, but the Crown's responsibility to prove if they are guilty and to assume that they are innocent. Also, the equality rights do not apply in this case. For terrorists, cases are treated a lot different than other criminal cases. For example, people who are accused of murders have in a fair trial receive full disclosure, while people accused of terrorism receive no mercy and no fair trial. Information is not disclosed to them, and they cannot help the case. These two cases for the accused of murder and the accused of terrorism are not so different, but they're treated in such drastic ways. The Charter of Rights and Freedom guarantees rights of individuals can be limited if they are demonstrably justifiable under the law in a free and democratic society. However, there was no oath test to justify the infringement. The Section 1, the reasonable limits clause, not apply to terrorism cases. If not, how is the accused's rights respected? It is fundamentally incorrect to assume the accused that false without first allowed a fair trial. The oath test is not granted, fundamental values, and what the legislation stands for is ruined. It will no longer be a free and democratic country. It will just be a police state ruled by people with power and those who have the power to decide who's a terrorist without first having a fair trial. So I would like to present an oath test. So first, prescribed by law and pressing is substantial. Yes. To protect Canadian citizens from terrorists. Is there a rational connection? Yes. To prevent terrorist activities from happening. In the proportionality part, minimum impairment? No. There are multiple charter violations that cannot be overlooked. In Section 38 of the Canada Evidence Act violates both judge and accused's fair rights at trial. This is not minimal impairment, but maximum impairment that cannot be justified under Section 1. In the proportionate effect, negative outcomes outweighs the positives since the accused cannot receive a fair trial, and therefore the oath test fails. If the court would also like us to refer to page 30, paragraph 25. Crown Counsel will also have an important role to play as proceedings unfold. For example, if it becomes obvious that Crown and non-disclosure under Section 38 will significantly and irreparably impact trial fairness, then the Crown itself ought to normally to stay out of proceedings. It is clear that concealed information about the Crown is controversial to having fairness in the trial. Why does the Crown have to hide information and refuse to disclose it to the accused? This is what the defense would like to know. Eventually, all the information will be revealed during the trial, so what's the point of keeping it a secret before the trial? The only way to ensure that legitimacy prospers is to be changes to the Canada Evidence Act. The defense believes that Section 38 needs to be read. That's the only way to guarantee a free trial. First, it should state in the Canada Evidence Act that all discrete information obtained by the Crown that has relevance to proceedings in the court must be disclosed to both trial judges and the accused, so that the Constitution can be applied. Second, the accused must receive fair trial regardless if it is a case of national security or if it's a case of criminal code. The Charter is upheld even in these extreme cases, and the oath test is always granted to ensure that the rights of the accused is respected. Thank you.
We are now starting the intervener session, and we would like to begin with Lishana.
I'm referencing from the Anti-Terrorism and Rights in Canada policy discourse on the relative balance, which was written by Patrick Casey and Siga. And the purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the importance of the right to privacy and the right to privacy. The purpose of this discourse is to explain the title of the November 1983 Special Senate Committee was Delicate Balance and Security Intelligence in Canada. At the time, the legislative compromise of Bill C-9, which created CSIS, Canadian Security Intelligence Service, in 1984, the CSIS did not meet all the tests of balance which the Fifth Field Committee had recommended. In 1980s, the Canadian compromise was to allow for and productive security intelligence service. The creation of both Inspector General and Security Intelligence Review Committee became Canadian contribution to the world of security intelligence and its governance. The initial operational concerns by the Security Intelligence Review Committee was the 5-year official review. The Parliament concluded the CSIS was in flex but not in crisis, which in other words says it's an issue but it's not as big. These acts affected the United States of America on September 11, 2001, which was the outcome of the Terrorism Acts. The balance of rights and security in many countries, including Canada, were immediately followed. The Bill C-157 and C-9 created CSIS because of the 9/11 Anti-Terrorism Act affected Canada. Canada had a hard choice on choosing rights versus security. The article seeks to do two things. First, to trace the debates around rights versus security in the early 1980s, creation of CSIS, and second, to look at this some debate around anti-terrorism and public order safety, close to the September 11 in Canada. Finding balance. Basic human rights were two fundamental issues: accountability and efficiency. Here, Self argued that the main questions in the government, in the general public, is how to find appropriate balance between these two values. It's not easy to find the right balance between accountability and efficiency. Security and rights during the late 1960s, 1970s, and early 1980s focused on 6 main questions, which were necessity: the security of the collectivity and individual rights, mandate, powers, structure, location, and control, and accountability. Necessity. The property of perceived needs for a distinctive security intelligence capacity has twofold. A, that there are threats to Canadian security, and B, that the Canadian state has the duty to protect itself from these threats. In 1968, the Kennedy Royal Commission on Security and the 1981 concluded that there were threats to the security of Canada. There were 3 types of threats McDonald mentioned. First, activities of foreign intelligence agencies. This threat requires the information that is necessary on terrorist techniques and methods. Second was terrorism. This threat requires CSIS for special events such as Olympic Games, G7 meetings, and summit meetings, or crises such as kidnapping and bombing. The third was domestic subversion, having frequent monitoring to keep Canadian society aware of what's going on. Trudeau's response to Justice McDonald's report was Bill C-157, which was a new law on security and intelligence. Within a couple of months, the government created a Senate Committee on Security and Intelligence, which held hearing in late 1983. Not all participants accepted all the conditions on supporting necessity or arguments. However, civil liberties groups were prepared to accept the necessity of securing Canadian interests, but had difficulty wondering how to find an appropriate balance between security, intelligence needs, and democratic rights. The security of the collectivity and individual rights. In 1982, Canadian Charter of Rights and Freedoms reminded Canadians that rights and freedoms were not absolute. Section 1 stated that the Charter guarantees the rights and freedoms set out in the subject only to such reasonable limits prescribed by law as can be demonstrable, justified, and of free and democratic society. The key policy reminded how to find the appropriate balance. On January 18, 1984, government introduced a new bill, Bill C-9, mandate functions. The primary mandate was contained in Section 14. Section 2 of the bill, C-157, set out the meaning of such as 1. Sabotage against Canada or any state allied or associated with Canada or supporting activities. 2. Foreign influences activities within to Canada that are detrimental to Canada's interests. 3. Activities within Canada directed towards or on support of the threat or use of acts of violence against personal property for the purpose of achieving a political objective. And last are acts directed towards undertaking by a government unlawful acts or directed towards or intended ultimately to lead to the destruction or overthrow. Powers. Section 22 of the original bill, C-157, set out the powers of CSIS. With a warrant, it allowed CSIS to intercept any communications or obtain any information or documents. This allows CSIS to A, to enter any place or open or obtain access, B, to search for, remove, return, or to extract from any record or object in any other manner. Structure and location. In 1968, Mackenzie noted that fundamental differences between security and law enforcement. Two issues stood out in 1981 in the policy discussion: A, location, and B, structural form. All but one of the Senate committee supported the bill C-157. Accountability. Pittsfield concluded that monitoring and reviewing was of great importance. Bill C-9 was a slight improvement over Bill C-157. Even civil liberties in general found it reasonable. Bill C-157 broke new ground in oversight of security intelligence agencies. Inspector General's duty was to monitor CSIS with its operational policies, to review operational activities of CSIS, to submit certificates. That's it.
We would like to hear from the next.
Terrorism and international crime, driven by Michael Lotus. This article argues that terrorism is an international crime and as such requires the international community to act in the prevention of terrorism and the sensation of individuals perpetrating the act of terrorism. Crime of terrorism is an act of non-governmental organization. In 1968, there has been a case where the Israel airline has been hijacked with 707 people on board, going from Rome to Tel Aviv. The purpose of hijack took place was to keep the passengers hostage until the release of Palestinian terrorists imposed on Israel. And another between January 1972 and 1974, out of 50 air suspects, only 7 Seven of them saw the inside of a prison, but the others were released without trial, even though the squad of Palestinians murdered Israel Olympic team. Declaring terrorism to be a subject of universal jurisdiction, the UN has made a statement to all non-state actors that resorting to violence as a means of securing political change, that no more would the terrorists solely be subject to censorship when caught within the territorial jurisdiction of the state where they committed the offense act, rather than the perpetrator of a terrorist act would be liable to criminal sensation wherever and whenever captured by lawful nation authority. People who are under the terrorist bombing convention, a nation can assert jurisdiction even though there has been no effect on the territory. It allows any state to have full authority to obtain jurisdiction over any person who is responsible for the bombing of a public place around the world. Any acts of terrorism are criminal and justifiable regardless of their motivation, whenever and by whomsoever committed, and are to be equally commended, especially when they are indiscriminately target or injure the absence of an operative definition means that, at least at the margin, the term is open to politicalized manipulation, conjecture, and political interpretation. The United States passed the Patriot Act, Canada passed the Anti-Terrorism Act, and the United Kingdom passed the Terrorism Act. Anti-Terrorism Act represents a massive and permanent change to Canadian criminal law with respect to terrorism, as it criminalizes not only acts of terrorism, whether executed or merely planned, but also criminalizes many forms of financing or facilitation of terrorism. The most basic definition is one of the three distinct elements, namely violence, a non-state actor, and a political purpose. Definition of terrorism becomes the unlawful threat or act of violence committed for a political purpose by a non-state actor. Stipulated definition is that it permits a wide range of actors, whether individual or a group, to be subject to the definition and therefore liable to censorship. They define the international and criminal law that is cases where the individual or group is unable to demonstrate adherence to the law of armed conflict and so ensure to granted of lawful combat status, an individual or group will be found to be subject to the purpose definition of terrorism and section under international criminal law. Definition of terrorism preclude to any international legal institution from taking effective action to combat terrorism. It is very clear that in order to be successful in countering terrorism contains basic principles from the foundation of an effective policy against terrorism, including firm, unwavering opposition to terrorism, maintain of the rule of law, no surrender to demands, no deals or concessions. The unlawful threat or act of violence committed to a political purpose by a non-state actor will ensure that all non-state actors that resort to violence for an unlawful purpose will be properly subjected to international law. This penalty of this failure is the price to be paid in continued terrorist acts and the cost in terms of both the loss of life and the harm of our global society as a whole. Canada's definition of terrorism is the first definition to act or commission committed in or outside Canada and which prescribed by the 10 UN Anti-Terrorism Conventions as they have been included into Canadian law and the criminal code. The second definition is the focuses act on a mission that internationally cause certain kinds of serious harm, including death, serious harm.
1 minute warning.
A serious risk to the health and safety of all public and or a serious disputation of an essential service or system, whether public or private.
We would like to call upon Anissa.
My name is Anissa, and I'm going to be preparing from Seeking Equilibrium, Canada's Anti-Terrorism Act, and the Protection of the Human Rights, and is written by the International Center for Criminal Law Reform and Criminal Justice Policy. May I proceed? I'll be referring to the Anti-Terrorism Act as ATA. The ATA was created after the 9/11 attack in the United States, Canada's federal counter-terrorist activity. The criminal code defines terrorism activity as lists accordance with conditions. So the history behind the ATA is that the ATA is a modified version of the 1939 Official Secrets Act, which was later renamed as the Security Information Act. This act created offenses dealing with unauthorized transfer of important government information. The act deals with the act of practice of spying offenses, including the threat of spying on foreign countries and terrorist groups. The creation of the Canada Evidence Act improved protection of information relating to international relations, national defense, or national security in the criminal or proceedings when creating the ATA. The government decided to take out Section 33 of the Canadian Charter Rights. The Parliament stated, and I quote, comprehensive measures to protect Canadians against terrorist activity while continuing to respect and promote values reflected in the rights and freedoms guaranteed by the Charter of Rights. When it came to the immigration IRPA security certificates in the UN Working Group of Arbitrary Detention, when considering Canada's fifth report of the ICCPR showed concerns and questioned the immigration security certificate compliance with the ICCPR. The Human Rights Committee had previously held a Ani versus Canada one side of the security certificate to use the summary of information was not unfair under the national security aspect. Canada held the immigration security certificate process clearly engaged in individual Section 7, the right of life, liberty, and security of a person may result to indefinite detention and possible removal to torture or other threat of their life and freedom. Security concerns cannot justify procedures and do not conform with the principles of fundamental justice. The government referred to the UN Council, Security Council Resolution 1373. This resolution calls on the countries to criminalize the financial support of terrorism, freeze the assets of alleged terrorists and their supporters, prevent terrorist activities obligations made mandatory and states under Article 41 of the UN Charter. So Article 41 states, and I quote, the Security Council may decide what measures not involving the use of armed force are employed to give effect to this decision and may call upon the members of the United Nations to apply such measures. These may include complete or partial interruption of economic relations and rail, sea, air, postal, telegraphic, radio, and other means of communication and the surveillance of diplomatic relations. The responsibilities of government is to protect citizens while the process of doing so ensure that they do not violate on the person's rights of those very citizens. Protection and restraint have common values within the human rights between the Canadian Charter of Rights and Freedoms and the International Covenant on Civil and Political Rights. They both include respect for the rule of protection for the individual rights and liberties, which is Section 7. The UN Human Rights monitors the agreement of countries with the ICCPR standards via the state reported obligations and where the appropriate, the HRC identified areas of concern regarding the agreement of the ATA and Canada's border national security framework with the ACC standards. So the violations of human rights when it comes to the ATA includes investigative hearings and recognizance with conditions. They are both used to gather information about the accused. Investigative hearings is a testimony of a witness and other person that may be compelled at early stages of investigation in respect of alleged terrorism offenses. Prior to consent of the Attorney General of Canada or province, a peace officer was needed to apply the investigative hearing therefore seek a recognizance with conditions. The recognizance with conditions was designed to prevent terrorist activities by allowing individuals to be detained and brought to court under judicial supervision for up to 12 months. Judicial review of detention within 24 hours and can be up to a maximum of 72 hours. A judge may issue an order to keep the peace and impose the conditions as may be reasonable in circumstances. My opinion is that the ATA does not infringe on Section 7 of the Charter, which is the right to life, liberty, and security of a person, because it was made to prevent terrorist activities from occurring in Canada. If the ATA protects citizens from such accused because they are detained. In the process, the accused are still able to voice their opinions on what has happened in investigative hearings and recognizance with conditions. The crime is able to gain evidence through this process to gain their case, and they are guaranteed a trial. The accused is still granted to have their opinion said, and it does not violate their charter rights. Also, both investigative hearings and recognizance with conditions in the interest of national security, they are able to keep Canada safe because they are not in society. That is all.
The judges would like to hear from the data.
You may proceed.
My name is Teresa from Russia, and I'm a member of the Senate. Today I'd like to talk to you about how I feel the ATA was rushed by Congress. My paper that I will be discussing with you today is from 2003 and expresses the Senate's opinion on the ATA. The Senate states many arguments in the text, including the pros and cons on the topic. In my opinion, I agree with the Senate argument against the ATA, which leads me to today's discussion on why. I'd like to bring the judge's attention to page 5 of the text and quote, Bill C-46 was hurriedly passed by the House of Commons on November 28, 2001, about 6 weeks after it was introduced for the first reading, and over 2.5 months after the terrorist attacks on New York, Washington, and Pennsylvania. It received royal assent on December 18, 2001, just 4 months after the September 11th attack. One may seriously question whether the government set aside enough time to adequately assess the full ramifications of adopting a wide-reaching bill. This states that just because the government was afraid something like 9/11 will happen in Canada, they passed the bill 6 weeks after it was introduced for the first reading and 2.5 months after the terrorist attacks in New York, Washington, and Pennsylvania. The government had passed the bill quickly in order to protect Canada without thoroughly reading the bill to recognize the flaws and issues in it. I believe it is factual that the government did not take the right amount, did not recognize the flaws and issues in it, did not take the right amount of time to check the bill. Considering fear being a reason for it, the government was afraid of the issues arising in Canada, consequently, and did not take the right measure in reviewing the bill, but just passed it into law. Furthermore, I'd like to bring your attention on page 6, where it states the numerous human rights groups who oppose the ATA. For example, the International Civil Liberties Monitoring Group on May 14, 2003 said that, I quote, the ATA grants police expanded investigative surveillance power to prevent detention, undermines the principle of due process by guarding certain information of national interest from disclosure during courtroom and other judicial proceedings, and calls for deregistration of terrorists accused of links with terrorist organizations. This explains that just because the ATA, the police have a lot of power. I believe that the police shouldn't have a lot of power just because of the ATA. It will make the police gain more freedom and more power in society while citizens' freedoms and rights are lessened because of the ATA. Next, the human rights group, the Federation of Law of Societies of Canada, pointed out some of the loopholes in the ATA. Therefore, I'd like to bring the judge's attention to page 6. I quote, the Federation of Law of Societies of Canada pointed out in their submission to the Senate on the Legal and Constitutional Affairs under Section 83.18(1) of the bill, a lawyer representing individuals or groups subject to provisions of the bill could be considered to be given a skill or expertise and service up to 10 years in prison. This violates the person's right to maintain and order independent counsel. The Federation of Law Societies in Canada explained that when a lawyer represents a group or group of people or person, it may be considered a terrorist crime even though they are only doing the job they are paid for. It also states that all lawyers who accept disbursements or professional fees may fall under the scope of Section 83.08, where it makes an offense to knowingly deal directly or indirectly in any property owned or controlled by or on behalf of a terrorist group. In my opinion, when a lawyer gives their knowledge on a specific topic to a client, that doesn't necessarily mean that they're involved in terrorist activity, and when a lawyer is paid to argue, all the lawyer is doing is the job they are paid by the client to do. Therefore, it is wrong to say that all lawyers who do that fall under the category of terrorist activity. The fundamental justice attack is when they allow investigative hearings to be used by the police who believe to have information related to terrorist acts that have been done in addition to Section 83.21, which allows judges the power to issue a warrant for arrest of individuals who have been ordered to appear at investigative hearings even though no trial or no charges have been taken. This infringes people's fundamental freedoms and that allows fairness. In 83.28, it states that if the police believe someone may have information related to the terrorist act, they may be committed. They will have to appear in front of a judge to answer questions and review material. However, according to the annual report, the government has said that these sections were never violated. Section 83.28 is a violation of citizens' charter rights and freedoms, specifically Section 11, where the person to be presumed innocent and proven guilty. In my opinion, it clearly does violate the citizens' charter rights and government infringement in press. On page 8, it explains the impact the ATA has on charitable organizations. Bill C-36 negatively affects charitable organizations. If the General Minister of National Revenue has reasonable grounds to believe that a charitable organization is trying to commit a terrorist attack, they can give a security certificate to take away the charity status. Charity organization may not really work in certain places in the world because they want to avoid the serious consequences that can come from these security certificates. The vast issue is what a charitable organization and privacy issues are considered. Charitable organizations are now being suspected of doing terrorist activity. This makes it unfair to other charities who are actually involved in charity work. The government should not suspect charities because not all charities assist, plan, or commit terrorist activities. In my opinion, I believe it's a good idea to keep in mind that terrorist activities might come through charities itself, but I think the government should find good proof to say that charity is doing a terrorist activity, because if the government is wrong, in the end, charity gains mass sense in the community for being suspected of doing terrorist activities. Therefore, it will affect the activity. Lastly, I'd like to jump to the page 9 to discuss about a few of the bills stated here. I quote Bill C-24 allows police to investigate, allows police to engage in a wide range of activities that will be illegal when investigating criminal activity, as well as providing more order measures for investigation as cross-section and connection. Bill 20 establishes the Agency of Financial Transaction and Report Analysis Center of Canada, where they collect, analyze, and disclose information in order to assist the detection, prevention, and deterrence of money laundering and of the financing of terrorist activities. Bill 44 authorizes the operator of any aircraft departing from or arriving in Canada to provide competent authorities in foreign states and other information a person on board are expected to be on board the aircraft. All the bills infringe on the citizens' privacy rights. In my opinion, the citizens' rights should not be violated for the purpose of security of the country. The government should make new laws that don't infringe citizens' rights while including the purpose of protecting the security of our country. As I previously stated about the human rights group, in my opinion, I believe that all human rights groups should be considered interveners in court cases instead of being either for or against. Human rights groups help citizens, but they're supported by governments, so adding them as interveners is the best way to utilize their skills and knowledge. Furthermore, as I stated before, on someone who was co-signing the ATA, I would like to make some suggestions regarding Anti-Terrorism. First of all, 83.18 states a lawyer representing individuals or groups subject to provisions of the bill could be considered to be given a skill or expertise, and so risk up to 10 years in prison. We should be more specific. It could say that if a lawyer gives their skill or expertise to a person who is not their client on a specific matter that suggests a link to terrorist activities, then the lawyer shall be punished. Or if a lawyer gives more than necessary knowledge to a client that has a link to terrorist activities, then they shall be as well punished depending on the type and how much information is given to the person. Another would be what I stated previously, lawyers who use disbursements and professional fees and fall under the scope of section 83.08, where it makes it an offense to knowingly deal directly or indirectly in any property owned and controlled by or on behalf of the terrorist group. It's the job of the lawyer to speak on their client's behalf, and the client must pay them to do so. I suggest that if the lawyer accepts disbursements and professional fees will lead to terrorists, but not for case purposes, then the lawyer shall be punished.
Thank you. The court will now like to hear the defense's closing statements.
So, my name is Cindy Tran, and I represent the citizens. May I proceed? A wise man by the name Pope Francis I once said, human rights are not only violated by terrorism, oppression, or assassination, but also by unfair economic structures that create huge inequality. It has come to the attention of defense, the Anti-Terrorism Act is not as simple or as fair as it has set out to be. There are many potential problems with the Anti-Terrorism Act, as it appears to be too broad in some parts, but at the same time too harsh in others, making the Anti-Terrorism Act an unbalanced act for Canadians to follow. We stand here today for one purpose, and that is to refine the Anti-Terrorism Act and achieve peace and order in our country. Defense understands the Crown's concern with terrorism and their methods to regulate security against terrorists. However, fundamental rights of an individual should not be sacrificed. We are, after all, in a free and democratic country. The law aims is to defend a person's rights by upholding the rule of law. Our supreme value is that no one is above the law. As expressed in the cases of Chinguacousy versus Canada, R versus Quadja, and R versus Condon, it seems that the Anti-Terrorism Act fails to respect the rule of law and violates various charter rights. The charter regulations include fundamental freedoms under Section 2, legal rights under Section 7, search and seizure rights under Section 8, trial rights under Section 11D in particular, equality rights under Section 15. Not only is the charter violated, but various parts of the Immigration and Refugee Protection Act is also violated. Section 96 of the Constitution was also infringed with the disability to access disclosed information. As you can see, this is a lengthy list of things that are wrong with the Anti-Terrorism Act. These things are becoming a serious problem that the Supreme Court can no longer ignore, nor can they overlook. We hope our arguments today have shed light upon many problems Canadians are facing when it comes to national security and terrorism. The Anti-Terrorism Act, as mentioned before, has a broad definition of what a terrorist is. Who's a terrorist? What is terrorism? Procedures of how to deal with terrorism are all questions with unclear answers. There should be a specific definition to avoid confusion in the future, and the defense strongly feels that Section 38 of the Canada Evidence Act should be revised and read in. We would like to remind the court that we do not support terrorism, but we are obligated to protect the rights of all individuals who are mistreated under the law. There are always two sides to every story. The defense hopes that the court is not judgmental and is willing to hear the accuser's sides before reaching a final decision. When there is fairness in the law and true legitimacy in the charter, that is when justice is achieved in the eyes of the defense. Thank you.
Thank you. Proceeding to the Crown of the final arguments.
Good afternoon, Your Honors. My name is Shana Singh, and I am representing the Crown with its closing statement. May I proceed?
You may proceed.
Okay. Every country has its own rules and regulations on how to maintain safety. However, the public has to be more aware now more than ever because we are faced with a lot of danger from various corners, and it is essential that we be aware of what steps are to be taken for protection in the event of an attack. Canada, which has experienced the Air India and Narita bombings, is no stranger to terrorism. This legislation, the Anti-Terrorism Act, is not an emergency legislation, but a permanent part of the criminal law in this country. The law is here to protect us from others doing harm to us and disrupting the peace in our society. The rights of society is at large to be protected from terrorism. Violent acts are much different than freedom of expression or freedom of speech. You still have the right to peaceful protest, questioning the government and law enforcement if they have acted outside of the law or constitution, and you still have the right of expression and free speech. The Anti-Terrorism Act extends the powers of government and institutions within the Canadian security establishments to respond to threats of terrorism and to protect all Canadians from threats and terrorist actions from occurring in this country. The Anti-Terrorism Act, along with the terrorism section of the Criminal Code, Section 83, is in place essentially to prevent terrorist activity before they occur. Prime examples of prevention are two major plots that were stopped by the Anti-Terrorism Act, the Toronto 18 and the Via Rail derailments. They were successful in preventing these plots due to the provisions that are present in the Anti-Terrorism Act. These provisions have assisted in preventing a catastrophe from occurring after the September 11th attacks. Now, comparing and contrasting the Anti-Terrorism Act with other legislations around the world, discussing jurisprudence along with various cases, including Mohammed Mohamed Khwaja, Chinguacousy, and R versus Ahmed, display why the Anti-Terrorism Act is so significant and why it needs to stay in place, which is to protect society from terrorist and terrorist activity, which is truly harmful to our society. Now, I would like to remind you again that the Anti-Terrorism Act is present to prevent and prosecute terrorist activities and ensure public safety from anyone that may pose a threat. It is not present to make assumptions on different races, and no book or any law has said that only Muslims are terrorists. It does not promote false assumptions. And due to the success of the Anti-Terrorism Act and the well-drafted and effective provisions of the Act, as mentioned previously, the Crown believes that these legislations need not to be reevaluated or struck down as the laws in place are affiliated with the Charter of Rights and Freedoms. The fundamental freedoms are not sacrificed, they are respected. And these uphold the values and rights of Canadian society, holding a high position among international anti-terrorism legislations and providing means to end for an international and universal challenge against terrorism. Thank you.
We are now going to start the question period, and my name is Justice Saha, and my first question is directed to the Crown, particularly to the defendant. Now, in your case, a major component of the Chinguacousy versus Canada case is how the charter applies to foreign nationals. On page 355, the case talks about detention of foreign nationals in comparison to detention towards permanent residents. And on page 357, the case talks further about the different treatment of citizens and non-citizens. It is clearly evident that the treatment of foreign nationals versus the treatment of permanent residents is an important issue to consider, especially pertaining to Section 78, Sections 80, subsection 3, Section 81, and Sections 82 to 84 of the Immigration and Refugee Protection Act. My question to you is, why did you not deem it to be necessary to direct the court's attention to this issue?
May I proceed?
You may proceed.
Towards your question, no. It's just
Justice
Justice Saha. I would like to say that I didn't have enough time, but I'll further elaborate on it now. Okay. However, the lack of the review of the detention of the foreign nations until 120 days is reasonable to a certificate and had been confirmed in Section 84. And the provision guarantees against the section in Section 9 of the Charter and the rights to review the detention in under Section 10C of the Charter, which there may be need of responsibility regarding the period of the substance of the terrorist detained and justify the complete detention time and the review. The provision of Section 9 and Section 10 justifies in Section 1 of the Charter. That was all.
My question is not completely answered. My question to you is that under Section 7 of the Charter, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principle of fundamental justice. And the wording states everyone, and this includes both foreign nationals and permanent residents. Under Sections 82 and 84 of the IRPA, foreign nationals cannot apply for review until 120 days have passed when the judge determines reasonability, until 120 days have passed. But a permanent resident can apply for review after 48 hours.
Okay, can I proceed?
You may proceed.
Okay. Well, this is a guarantee that against unusual treatment cannot be challenged over the fairness of a particular government decision. The detention without the whole release and the legal procedure of the release can be stressed and therefore unusual treatment. As you said before, the Immigration and Refugee Act of the residents is a danger to national security and detain review for 48 hours. The following of the review of the foreign nation is 120 days. Because the flexibility regarding the period of the suspect of the terrorist may be justified and completely denied the time of detention reviewed.
I'm Justice Raw, and my question is for one of the interveners, which is going to be Rishan. You explained your position paper but failed to give your opinion on the Anti-Terrorism Act, and if you believe that keeping or striking down the ATA is better. So my question to you is, what is your opinion on the ATA? Would you like it to be struck down or upheld, and why?
be upheld because it should be people's safety over civil liberties.
I'm Justice B, and this question is for the Crown. Can you please explain further on preventive arrest?
Your Honor, may I proceed?
You may proceed.
The Anti-Terrorism Clause of Canada and the United Kingdom have special clauses on investigative powers. First, if a judge has reasonable grounds to believe that a terrorism offense has been or will be committed, and that the person named has information about the offense or about suspect, he or she may order an issue for that person's examination. If a person does not show up, a warrant may be issued for his or her arrest and production of testimony. At the hearing, the person is entitled to legal representation, but may not refuse to answer a question or produce an item on the basis that it is incriminated. However, if no answer is given or nothing is produced, that may be taken as evidence against the person in a subsequent criminal proceeding. Now, in terms of preventive arrest, a piece of Canada's Anti-Terrorism Act allows preventive arrest. The peace officer may lay information before the court only if he or she believes on reasonable grounds that a terrorist activity will be carried out and these measures are necessary to prevent it. Now, the officer may make a warrantless arrest in the event that grounds for information exist, but circumstances for the officer is disallowing him or her from doing so, and he or she believes it is necessary to do so to prevent a terrorism act. Now, similar to Section 495, subsection 1, subsection A of the Criminal Code, which allows an officer to make a warrantless arrest if he or she believes that the person is about to commit an indictable offense. Now, in such case, the officer must bring information within 24 hours or as soon as possible to the court. Now, since the Anti-Terrorism Act is similar to the Criminal Code provisions, allowing the detention for a good cause meets the Charter's guarantees under arbitrary detention. Now, two safeguards in the Canadian investigative hearings and preventive arrest provisions are: first, federal and provincial attorney generals must prepare annual reports detailing the use of compelled testimony and of preventive arrest provisions based on information and warrants. Second, the Solicitor General of Canada must also annually report on warrantless arrests. A statute also includes sunset clauses in which investigative hearings and preventive arrest provisions automatically expire within 5 years but can be renewed. Now, this is done to ensure that they are only used in emergency measures and do not become normalized as they have in the United States of America. Thank you.
Hello, I am Justice Dunner. I would like to hear from the intervener, Parliament, on the specific paper of Michael Wallace, Terrorism Defined. It issues terrorism as an international crime, and the community needs to act to prevent terrorism and the acts of terrorism. The United Nations has the responsibility of the universal nations to help prevent crime and terrorism, which we fail to stay in here today. Also, the matter which hinders the most at the current time is the lack of international regulations on terrorism as a crime under the law and how it is determined to be criminal. Even though that this threat of terrorism regulates with international borders, the international community labels that a criminal offense. However, there is no international consensus on how to bring terrorists to justice and to prosecute them more vigorously. Also, the failure to adequately cause alleged terrorists to be subject to judicial sanction weaken efforts at the national and international level for a coherent international judicial institution within which to deal with terrorists. Ultimately, incidents of terrorism increased throughout the 1970s and into the present, in which terrorists are becoming increasingly sophisticated and capable of committing larger and more devastating acts of violence. Evidently, my question to you is this due to little any deterrent effect on terrorists, and mainly, does this affect Canadians as a society?
Yes, it does affect the society because who would want to live in a country with terrorism in it?
Justice Signani. This question is posed to the defense, specifically Devin. You stated that jihad is not a holy war and has no specific meaning. Jihad is a struggle or effort which is defined in a specific meaning. But in what law does it speak about jihad specifically?
May I proceed? I just want to clarify one thing. The jihad is not specifically said in any law. But why I brought it up was because my friends kept saying that Mr. K was involved in the so-called jihad between the West and the Middle East. As I stated before, the jihad is not specifically a holy war. It is a struggle between those who follow Islam and those who do not. My friends kept saying that there was violence that was being committed by Mr. K and towards the West. So what I wanted to clarify was that the so-called jihad that was being talked about is not this holy war, but it was a struggle between those who follow the Islamic religion and those who do not. In law, it was, how it relates to law was that there's part of 2A, freedom of religion, and how this has been infringed because those of the Islamic background have been put underneath the prejudice of being considered a terrorist or part of a terrorist activity.
Justice Batch. This is directed to the defense. Can you please elaborate on Section 15, equality of the Charter rights and freedom, and how it violates between non-citizens and Canadian citizens?
Elaborate on what you just asked. Section 15 of the Charter of Rights and Freedom. Under legal rights. States that every individual is equal before and under the law, and has the right to equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental physical disability. Now, this relates to what we just said, which you just asked, because Section 15 of the Charter of Rights and Freedoms was violated because after the attack of 9/11 back in 2001, in 2003, these 5 men were accused of being suspect terrorists, not because of what they've done, because they're Canadian, they've been not Canadian soul for over a decade. And it's been only 2003 and until now that they were detained and they were questioned. And so because of their race, having some kind of affiliation with, when they believe that has an affiliation with Al-Qaeda, they assumed that they were suspect terrorists.
My name is Justice Sanju, and my question is for Karen from the Crown, Mr. Chair. You provided a very nice in-depth summary of the Anti-Terrorism Act during the argument, but you failed to clearly express how your information relates to current circumstances. Can you please clarify?
Your Honor, may you please clarify the question? I did not completely understand it.
You provided a very nice in-depth summary of the Anti-Terrorism Act, but you failed to relate that act to today's events, to the current circumstances.
Now, in relation to the definition of the Canadian Anti-Terrorism Act, which states that an act of omission that's committed in or outside Canada and that is committed in Canada in the offense of intent designated international conventions to the Convention of Terrorism and onwards. In relating this to occurring next day, we take into account the Omar Khadr case. Now, in relation to the Omar Khadr case, if the act was committed inside Canada, so for example, Omar Khadr's brother, he was given a fair trial, and to state his name, dual father. He was given a fair trial within Canada because he was solely arrested within Canadian borders. Now, in reference to his brother, Omar Carter, he was detained outside of Canada, and in this circumstance, he was not. He was given a trial under the rights of the other nation which he was detained in, which was Afghanistan, and then therefore he was taken to the United States. So just to further clarify that, the Canadian definition describes it as an act or omission that is committed in outside Canada, and that if committed in Canada is an offense under 10 designated international conventions for the prevention of terrorism, and if detained within Canada is given a fair trial within Canada and within Canadian rights. Thank you.
Thank you. I'd like to take the time now to remind all present in the courtroom today that anyone and everyone disrupting the court while in session will be held in contempt of court and will be removed from the vicinity. Thank you.
I am Justice Mirza, and I have a question for the Crown. Under the Anti-Terrorism Act, authorities can use surveillance for up to a year without performing summons. How does this protect the privacy of individuals? Can you see the number?
So when it comes to surveillance cameras, and it basically is a public safety issue in general. They are present there to protect and basically look upon what may happen in the future. So when it comes to the Toronto team, those terrorists that were conducting training camps in Ontario, they basically used amassed weapons and made plans to storm the Parliament, where they intended to behead politicians. But ahead of time, the CISAs, they came across these videos and prevented this from happening, and they got the Toronto team arrested, and this prevented a huge tragedy from outbreaking, which could have threatened the Parliament in general. As well as, when it comes to surveillance cameras in overall, it is a really big public safety issue. They are there to protect us from anything happening in the future, and they will, in the future, make a difference because this way society won't be frightened, and information that may be a threat will be given out to bigger officials, so no problem is solved in the future. That's all.
My name is Justice McDonald, and I have a question to the Crown. A common criticism of the Anti-Terrorism Act is that the legislation targets Canada's homophobia. How does the Crown suggest the law is changed so Canadians not feel targeted based on racism?
May I proceed? Now, the Canada and the United Kingdom take steps to prevent terrorism at its roots through hate crime provisions directed against, for example, religious prejudice. The Anti-Terrorism Act punishes any mischief towards religious places of worship when the action is motivated by bias, prejudice, or hate based on religion, race, color, national, or ethnic origin. As stated earlier, Canada defines that the definition of terrorist activity as a motive that is pursued by political, religious, or ideological purpose, objective, or cause. Now, the Anti-Terrorism Act does not present new provisions, but expands on existing ones to cover the spread of hate material, for example, over the internet. Now, any religious hatred, along with racial hatred, is an aggravating factor for existing offenses. Hatred based on ethnic origin, language, origin, color, religion, sex, age, mental or physical disability, sexual orientation, or any other similar factor also exists as an aggravating factor. Now, a common criticism of the Anti-Terrorism Act, as stated, was that it infringes upon Section 2B rights, the freedom of expression. However, under Section 1, there is no limitation clause. It would seem reasonable to justify this infringement under Section 1 as promoting multiculturalism as tolerance, as terrorism need not see race. Terrorism, when targeting the public or a sector of the public, does not deem a specific race and does not target a certain multicultural area. Now, as I was stated, however, in regards to the infringement of Section 2B, once again to state, it would seem reasonable to justify this infringement under Section 1 as promoting multiculturalism and tolerance, thus upholding Canada's multiculturalism mosaic. Thank you.
This is directed to the defense team on that. I feel like my question is unanswered, but part of it. In your article, it specifically talks about the equality violations between non-citizens and Canadian citizens, between detention. Can you please elaborate on that part?
May I proceed, Your Honor? To answer your question between what a non-citizen and a citizen of Canada is and how equality is approved. To answer your question about non-citizens and citizens about equality is not addressed.
It's about between detention and detention.
Well, for under the ATA, between people of religion and people of non-religion, let's say we consider them as citizens, let's say. They're equal to each other. They're equal to each other because, yes, although yes, people are suspect terrorists, and because they believe, because the government believes that they are affiliated with a terrorist group, such as Al-Qaeda, who they assumed was all Muslim people, but of all Muslims, they believe that they were all Muslim people who committed this crime. However, these 5 individuals, such as these 5 individuals, Hussein Al-Amri, Mohammed Arkat, Mohammed Jabal, Mohammed Zaki Maji, including Mr. Charlie, they were in fact Canadian citizens before this all happened, before the detainment actually happened. So, but because they were believed to be of terrorists, because they believed to have affiliated with any terrorist plots, CSIS, the IRPA, believed that they had committed a terrorist act. In all honesty, in my opinion, the fairness between both of those 2 groups, such as non-citizens and citizens of Canada, I believe that they should be treated equally, because after all, everyone is a human being.
Is this the only way Section 15 of the Charter of Freedom is being violated? Just what I just said?
Could you please clarify that?
Is this all the reasons why Section 15 is being violated? Because in your article, it states that it's also being challenged because non-citizens can be detained and Canadian citizens cannot. So there is an equality. They find it's unequal that Canadian citizens cannot be detained and non-citizens can.
Well, may I proceed? Going along with the IRPA, what they said that they only detain immigrants and interrogate them, if you would like to say that. They interrogate them because they have no idea of where those immigrants came from. And as Canadian citizens who have been living here, they too should be detained if they have any affiliation with a terrorist plot. But it seems unfair and unjust that the immigrants, the foreign nationals, are detained and immediately deported for where they came from.
My question is for the defense, and in particular for Sabi and Megan. You both explained your position papers and what they were about, but failed to apply them to why the Anti-Terrorism Act should be struck down. So we would like you to send up a representative to explain why the ATA should be struck down relating to your position papers.
Your Honor, myself and my colleague Megan have stated that we kind of say that the ATA should be completely struck down. We want it to be read in, and we think that the definition of terrorism is too broad for the ATA to be enacted. That's all.
Sorry, my question was that I wanted you to relate your position paper to why you think the ATA should be struck down.
Okay, as I said before, that we were left with the unfortunate conclusion that Canada's new law violated very constitutional values that render our society civil, simultaneously failing to protect us from terrorism. So my colleagues communicates the ATA Act does simultaneously fail to protect us from terrorism when we are under action of the community. And that's it. And the Anti-Terrorism Act does not follow the rule of law, especially regarding due process and conspiracy, because there isn't an exact process. And everyone does deserve the right to a fair trial due process. And furthermore, the definition of terrorism is too broad to carry out the Anti-Terrorism Act, as I said before, and it distracts attention and trial and potentially more useful measures. And that's all, Your Honor.
The next question that I'm about to pose is for the Crown, particularly Mr. Malik Sam. Now, it is evident that for the judges that jurisprudence is important because it guides us through what decision we should take and how we should take it. Now, in your argument, you stated that formal jurisprudence is the best form of jurisprudence compared to the other two. Now, based on what you said, formal jurisprudence is very similar to legal formalism or the letter of the law, literal interpretation. Now, my question to you is, why should literal interpretation or formal jurisprudence be considered when the Supreme Court of Canada, as of right now, uses legal realism as a jurisprudence, which is the complete opposite of what you believe? In your argument, you did not talk about the case of United States of America versus Burns, where extradition to capital punishment, and I believe that this sets an important case precedent in relation to extradition and how a different country will react to extradition. Now, can you please elaborate on that case as well?
May I proceed?
You may proceed.
So in dealing with the constitutional law and formal jurisprudence, this particular about the fundamentals of the Constitution where basic values are concerned. This approach views itself as being unbiased, and this coincides with the courts in dealing with international laws when dealing with terrorism because it is a threat to national security. Concluding and dealing with emergency situations is wise to take a formal jurisprudence approach, as it will stay in line with the charter, but also take into consideration as the legitimate outcomes. And for the second part of the question, dealing with extradition. Extradition laws are different from country to country, as in where Canada, it sets the limits on, so for example, the sunset clauses, from where Canada has sunset clauses to better shape the ATA Act.
So, Mr. Sands, does that mean you believe that judges should not have room for interpretation because of formal jurisprudence?
Can you repeat that, please?
As I said before, formal jurisprudence is very similar to legal formalism. So my question to you is, do you believe that judges should not have no room for interpretation if in formal jurisprudence everything is written as the law should be applied as the law is stated?
With formal jurisprudence, courts should take into consideration the charter, but also take into consideration international laws when international laws.
for the defense, in particular, how does national security surveillance violate privacy laws under Section 8 of the Charter?
Your Honor,
You may proceed.
it violates privacy. Privacy is key in life. It's what keeps conversations between a friend from not being told around the world. That's how it violates it.
All right, next question which one I posed to the defense, specifically Cindy. You were talking a lot about the rule of law and how it applies to the Anti-Terrorism Act. Even though there are multiple definitions of terrorism seen in the legislation, we still need a distilled definition of terrorism to effectively act against the problem of terrorism. So my question to you is then, wouldn't the rule of law be more fully respected if the operational definition of terrorist were clearly set out in law instead of it being left to the Attorney General's discretion?
May I proceed? Okay, as I stated before, the rule of law has values and standards from acting rights and freedoms of individuals. Here, if there is no clear and specific definition of what terrorism is, it is interpreted in a wide range of ways. If there's no clear definition, people can interpret terrorist of being a simple man on the street, or it can be interpreted as someone who has committed a violent crime. If there's different interpretations of law, how are we supposed to say it's fair? There will be different precedents that will be laid out, and so when you're dealing with law, it'll cause confusion. That is why we, the defense, would want a specific definition first, and then towards legal realism, have the courts then decide the case due to the circumstances. Thank you.
The next question is posed to the Crown, Ashana in specific. You spoke upon an reasonable person. Can you please define what a reasonable person is? Are we all reasonable persons? Are you a reasonable person? Am I a reasonable person? Please define what a reasonable person is.
Okay. May I proceed?
You may proceed.
So, according to the legal dictionary, a reasonable person is a hypothetical person in society who exercises average care, skill, and judgment in conduct, and who serves as a cooperative standard for determining liability. Thank you.
Directly to Tim, can you clarify on the arguments of section 11B and B of the Charter of Rights?
Now, answering your question, Justice Ash, 11B provides that everyone deserves a fair trial. However, these men were not given a fair trial at all. They were immediately detained without a question. 11B of the legal rules. This is supposed to prove that these men are innocent until proven guilty. However, they just assume.
Mr. Walton, please call 406. Mr. Walton, 406.
However, CSIS IRP assumed that they had any affiliation with the terrorist plot, and so therefore they were not, and so they were guilty immediately by those two groups. John, any further questions, John?
Yes. can you actually specifically state what 11B states and which other way it's actually written down?
Can you just clarify that again?
Can you please tell me the actual, can you please tell me what 11B is that actually written in the Charter of Rights? It is written here. Is it right to a fair hearing, as we said?
It's a right, yes, there is a right to a fair hearing. Is what I meant, which there thus meaning a fair trial. Under fair trial to the court and has a fair judgment.
Section 11B states to be tried within a reasonable time. I can understand the argument of a fair trial, but that does tie into Section 11, but not B specifically. I believe you're trying to say it ties into 11D when it comes to innocent until proven guilty, and that's how a fair trial works. Is that what you're going to say?
He's right. Well, under Section 11B and D, the legal words. Let me first state that B, they were not given a fair trial at all. Yes, they were. There was no trial during this article. Now, following 11D, during their interrogation, IRPA and CSIS just assumed and placed them under the category of a terrorist without having real evidence. Thus, they were not proven guilty. They were still innocent at the time. Any further questions, Your Honor?
Yes. You talked about the rule of law and how it's not being upheld. Can you just please explain how it's not being upheld? Because I do not understand.
Well, the rule of law and the protection of one's rights. It is now following to Section 15, the equality rights. Yes, Your Honor?
Section 15 of what?
Section 15 of the Charter of Legal Rights. As I was saying, the rule of law and protection of one's rights is perhaps the most important thing in Canadian society, also along with the justice system. But we the defense believe that indefinite detention of a person who's never been convicted of an offense or anything, well, a citizen in general, we believe that indefinite detention should be struck down, or if not, read out some parts of the IRPA's procedure. Their security certificate procedure relates to the indefinite detention because these men, as I said, with case precedents, these men were immediately detained. Any further questions?
My next question is for the defense, particularly Mr. Harshey. Now, you argued about the dictionary definition of a terrorist. You stated that the societal definition of a terrorist is a colored person. You declared that Mohammed Harkat was a permanent resident, even though specifically on page 354 of the Chinguacousy versus Canada case, it clearly states that Mohammed Harkat, or Mr. H, is a foreign national who has been recognized as a conventional refugee. You argued that the media would assume a Muslim would be a terrorist if he was protecting a boy from a dog. And you stated that some Muslims are nice. My question to you, Mr. Harshdeep, is what are your exact sources? Where did you get these wild assumptions? Where did you come to these conclusions? What were your sources for these conclusions?
May I proceed? The dog example was hypothetical. It was just an example to show how the media would react to something like that.
You are in a court of law, and I would ask you to not quote from a dictionary or use assumptions. Thank you.
This question for the defense, and in particular Sally. Can you please explain the analogy of devil visiting the devil in terms of terrorism?
The RICM commissioner Zachary responded saying that obviously we have to strive toward as told than what we are normally used to seeing in this country. We are in the active discussions about what this means because the devil is in the detail. As we know, it is easy to read, but it is how we apply and how we put this which will determine how this really works. As the devil is in this detail, he basically meant that, like, he said it's easy to read, but it's how we apply it. And as I said before, the police officers do not know how to enforce the law. And that's what he meant by the devil is in the detail. As we know, it's easy to read, but it's how we apply it.
Thank you. My question is also for Ms. Sally of the defense. During the arguments, the terms good guys and bad guys were utilized. The court is unsure what was implied by these words. Could you please define those terms and explain their use today in relation to your arguments?
When I said that bad guys, and it's hard to determine who the bad guys are and the good guys are, it's because, as I mentioned, charity that give resourcing and fundraising to groups don't know like I was trying to explain that the ATA Act would consider that as terrorist activity if a charity group gave resources and fundraising to a group, but I was asking that would it still be considered a terrorism activity if the charity did not know it was a terrorist group at the time. That's all. Any more questions, Your Honor?
All right, posing another question. My question is for the interveners, specifically Cohen. However, throughout your hearings today, you have acknowledged the most important fact and the most basic definition of terrorism. This, however, has three distinct elements which I would like you to explain, and accepting these three constituent elements, what does the definition of terrorism become?
May I proceed, Your Honor?
Proceed.
Well, the Anti-Terrorism Act is in place to educate students to basically know what terrorism is and how it can be prevented. It is there for the purpose of preventing terrorists from outbursting. And like any other thing, the Anti-Terrorism Act, the main purpose of the Anti-Terrorism Act is to provide means by which terrorism is to be prosecuted and prevented. Along with that, anti-terrorism it educates citizens that live in our country where they want to be protected. But if the country is under the threat of other countries, the citizens will no longer feel safe. The Anti-Terrorism Act is present to prevent these tragedies from happening, as well as they are here to keep citizens safe. It is not an unbalanced act or anything. It is an act that keeps balance and guarantees a structure in society and prevents outbursts of terrorist attacks. Thank you.
Question is directed to the defense, specifically to Megan. In your argument, you talked a lot about Section 8 of the Charter of Government Freedoms. Can you please elaborate?
Your Honor.
Proceed.
So Section 8 is the unreasonable search and seizure. This, in my article, the unreasonable search and seizure is the privacy of the communications. You're taking people's conversations and like using them against them.
Directly to the Crown, specifically Karen, in this opening argument, you talked about charter violations. May you please repeat the sections that are being violated?
One minute for Crown Counsel.
Governor, may I proceed? Just to clarify for the court, I was not stating in my opening statement that these charter violations were violated. I was stating that these are charter legislation that may be brought up during our arguments. Now, recognizing the rule of law as an overarching principle, the charter rights and freedoms are of particular importance to this review are freedom of thought, belief, opinion, expression, conscience, religion, peaceful assembly and association, which is Section 2, security of the person, including privacy, Section 7, equal protection and benefit of the law without discrimination, Section 15, security against unreasonable search or seizure and arbitrary detention, Section 8, and the right to a fair trial and presumption of innocence until proven guilty, Section 11.
I started learning this, but can you repeat section 8 right now?
I apologize, I did not hear that.
Please finish up. Start out with when you said section 8 and say whatever you want to say.
Sure. So, prior to Section 8, I said equal protection and benefit of the law without discrimination, which is Section 15. Section 8 is security against unreasonable search or seizure and arbitrary detention. And Section 11 is the right to a fair trial and the presumption of innocence until proven guilty. Thank you.
The next question is imposed to the Crown. It is a general question. It was mentioned that terrorist activities harm people and their public safety. However, when defining terrorism, does terrorism only apply to harming persons physically? What about psychologically or emotionally? Is that included in the public safety?
May I proceed, Your Honor? When it comes to public safety, it is not always about harming one another, or causing injuries, or causing harm to one person. It is also about emotional and mental problems. Well, when we think about it, 9/11 attacks, the aftermath of those families that lost loved ones did go through a very hard time. And that is because they lost loved ones. And that is one of those terrorist activities that took away lives of many people. So it's not always about harming one another, it is also about emotional loss that one person may face. Thank you.
Judges, you have 5 minutes remaining.
My question is for the defense, in particular for Tim. You explicitly stated that North America believed that anyone of Muslim religion may or has been in a terrorist group. By you stating this, you gave the impression that North America discriminates against Muslims and that Muslims are mainly affiliated with terrorism. A statement like this is discriminatory and it could stimulate serious conflict. Is this your own opinion or a fact? If it is a fact, where did you obtain this information from?
May I proceed, Your Honor? Now, to answer your question, Justice Say. I apologize. What I meant was that I did not say that North America in particular, is thinking that, is being biased and thinking that all Muslim people of Muslim background are the terrorists. What I meant was, the Western society today, how they broadcast media, they advertise the fact that they try to send a message that people of Muslim religion have something to do, well, have an affiliation with the terrorist plot. Now, because the Western society, the society portrays that media today, we the defense group feel that the media of North America is trying to broadcast a hate message towards, well, trying to make everyone be prepared just in case of what a terrorist attack is. And may I mention that a terrorist attack is, a terrorist is only a person that causes harm or violence. Any further questions, Your Honor?
Our next question is now posing is towards the Crown. Now, this is a general statement and an actual fact. The U.S. invaded Pakistan with drone attacks in order to kill leaders of the insurgent groups. This can be argued under the acknowledgement of wrongful execution, which states a miscarriage of justice occurring when an innocent person is put to death by capital punishment. They have also denounced the U.S. attacks Pakistan, making the U.S. guilty of war crimes as they do not have explicit permission from Pakistan's government. Now, the question at hand is, what if Canada engaged something similar to what the United States have done? Was Canada labeled as a terroristic state under the Anti-Terrorism Act and under the International Terrorism Laws and Acts? And what also differentiates Al-Qaeda from being an active terrorist group when compared to the United States in this specific scenario, since the United States is also an ideology towards the political aim, which is defined under the definition of terrorism.
1 minute for the Crown. That was the last question. Crown Counsel, can you please proceed?
Now, to answer your question, the definition of terrorism. The definition of terrorism, as stated earlier, was an act or omission that is committed within or outside of Canada, and because it's within Canada, it's under the 10 listed motivations of the terrorist prevention. Now, this definition matches the Canadian, for the Americans. This definition matches the Canadian and the British. However, it lacks the element for the purpose of political, religious, or ideological motivations of the perpetrator. This lack of element weakens the definition, failing to get full recognition of terrorism. So the United States definition differs from Canada in that sense, and furthermore, Canada's involvement with the Canada's prevention of the Al-Qaeda attacks would differ because Canada does not have capital punishment to begin with, and the United States has different provisions such as the capital punishment, which is legal in some states, and the preventive arrest, which is not a special clause in the United States. It is a permanent clause, which is part of their legislation. So, once again, the state, Canada does not have capital punishment as part of the legislation, and the American definition lacks the element of purpose for political, religious, or ideological motivations of the perpetrator, and this lack of element weakens the definition, failing to get full recognition of terrorism. Now, this makes the prosecutor's job easier by eliminating subjective elements to be proven, and this definition becomes too broad by allowing terrorism charges for crimes lacking any real ideological motivations. Thank you.
This ends the court session for today. We are in recess until Monday, November 11th. Thank you.
All rise.